Were they here and left? Back on the record in the case of People versus Linda Stermer. Any matters to address before we bring in the jury?
We have none, Your Honor.
Mr. Mueller or Mr. Kelly, any?
No, we have none, Your Honor.
No? Okay, we'll bring in the jury. Welcome back, jury. Good morning. Start with an apology. I'm sorry for the late start up this morning. It's my fault. Okay. Counsel, Mr. Mueller, you may call your next witness, or Mr.
Yes, Your Honor. We'd like to call Mr. Steve Benny to the stand.
Good morning. Good morning. If you raise your right hand, please. Do you solemnly swear or affirm that the testimony you're about to give in this cause will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Please have a seat, and once you're settled in, we'll have you give us your full name and spell the last, please. And make sure that microphone's right up to your mouth.
Christina Lynn Benny, B-E-N-N-Y.
Okay, thank you. Mr. Kelly?
Good morning, Ms. Benny. Do you know Linda Stermer?
Yes, I did.
Okay. And did you know Mr. Todd Stermer?
No, I did not.
Okay. And could you briefly tell me, how did you know Miss Linda Stermer?
Through Kate Fox.
Through Kate Fox?
Mm-hmm.
Okay. And other than just being introduced to her, she being introduced to you by Kate Fox?
Yes.
Have you ever had any other dealings with Ms. Stermer?
As far as what, I mean, before that we didn't know each other until my sister-in-law introduced. I didn't know Linda until my sister-in-law introduced us.
Okay. Have you been to Ms. Stermer's house?
After the fire.
After the fire?
Mm-hmm.
Is that the only time that you've been there?
We were there one time for my husband to look at a vehicle that wasn't working.
For your husband to look at a vehicle that wasn't
Yes.
working? Okay. And So that was the only time that you'd been to their home, was one time when your husband was over there to look at a car?
Yes.
Okay. Did you happen to go to their home after January the 7th of 2007?
Yes, we did.
And for what purpose were you there at that time?
To get some materials to build a lean-to for the horses that we were going to take for her, and put, we got the materials from the lean-to that was on the property. So we had to tear some of that down to take to Kathy Eel's property to build a lean-to for a horse.
Okay, and what was your responsibility for Ms. Stermer's horses?
To take care of them. We had some horses on the property she had nowhere to take them, because there was no power, no water, no nothing on at the property. So she asked if we could take some of her horses to our property.
And so this material that you're talking about taking material from the Stermer's property?
Yes.
And
It was in a lean-to. It was in the pasture. It was next to a semi-trailer and a tractor. So we took some of the material down to put another lean-to up on Kathy Eel's property.
okay. And then you moved the horses.
Yes.
How many days did it take you to do that?
Not very long. I think we moved it all in 2 days, I'm pretty sure.
Okay. And did you have any other activities on the property?
Yes, we did.
And what was that?
We went to the property to get some other materials and go through some of the ashes that were in the bottom of the basement of the house to see if we can find Linda's rings.
And that was a request of Ms. Stermer?
She wanted some help to go out there. We took it upon ourselves to help her out, yes.
And what did you do in reference to helping her out with going through the property?
We went out there. There was a pile of ashes in the basement. We went through that, made a makeshift screen where we could take shovels and dump it on top of it and shake all the loose stuff out of it to see if there was any materials like rings or anything else like that that would stay on the top of the screen.
And did you find anything?
Oh, yes. We found rings, we found baseball cards, there's some other odds and ends pieces of jewelry that we found.
How many days did it take you to do that?
About 3.
About 3 days?
Non-stop, yep. We went out there one day, was out there until it was almost dark, and then we left, went back the next day, and the next day.
When you say we, who are you referring to, we?
The first day it was me and Linda, Brittany, the 3 boys, and my husband, Steve.
Okay.
Oh, and Kathy. Kathy was out there before we went sifting through everything.
And this is Kathy who?
Kathy Eel.
Okay. And you stated that the three boys was there also?
Yes.
Okay. And where did you find the baseball cards at?
In the fire, in the stuff that was laying in the basement.
Was it in a container? Were they in a container?
No, these were loose baseball cards. And some of them were in, I guess you want to call them, photo albums.
But they survived the fire?
They had some burning and they were pretty wet. I mean, the stuff was wet. They were stuck together. You had to actually pull them apart.
Okay. And did you do anything else in the, you referred to this shed, or is it a lean-to?
It's actually a semi-trailer that used for storage. And then they had another shed on the property that had hunting materials and deep freezer in it and all kinds of other stuff.
And did you go into the semi-trailer?
Yes,
That was used for storage?
yes.
What was your purpose for going in there?
Our purpose is to go in there to see if we could get anything that related to the horses or anything else that we might have forgotten, to make sure that we get everything we need before we moved all the horses. And there's some other odds and ends, and then that was it.
Did you remove any personal household items out of the shed?
No,
Okay. Did you hear any conversation about any household items in the shed?
as far as what household items are you
Or
referring
valuables of the family?
to? I'm sorry.
Valuables of the family?
There was boxes of pictures in there,
What kind of pictures?
photo albums, picture frames with the pictures of the family, the boys.
And you saw those?
Yes.
And did you see anybody remove them from the
Yes.
trailer?
Well, we picked them up and moved them out of the way because we want, we couldn't figure out why they were in the semi-trailer in the first place.
Had you ever been to the house?
No, I have never.
Did you make any comment to anyone as to why they were in the trailer?
Well, I made a comment that was weird, that boxes of pictures were in the semi, and so I said something. Well, we were all standing right there, and it's like, why are there boxes of pictures in the semi? And that's when Linda says, I don't know. And so that's when we asked the boys.
You asked the boys what?
If they knew that the pictures were in the semi-trailer.
Do you know which one of the boys you asked that?
I get the two boys mixed up, Trenton or Trevor. So I don't know if, I'm pretty sure it was the youngest son said.
Excuse me,
that.
Your Honor, that's objection hearsay.
I'll sustain.
Did you hear any statement at all about the box of pictures?
Objection hearsay, Your Honor.
She can say what she
She can
heard.
answer whether she heard a statement, and the content of it, though, is going to be objectionable.
What I heard was,
Okay, yeah. So there's a hearsay objection as to
Okay.
what she heard. One moment, ma'am.
So did you hear a statement, not saying who's
Yes.
made a statement,
Right.
but did you hear any statement about,
Your Honor, I'm going to object. It's hearsay.
I mean, she can testify to what she heard.
There's a hearsay objection, and what is your response to the hearsay objection?
It's not hearsay if she literally is standing outside and hears a statement being made. I'm not asking her about the truth of the statement. I'm just asking her, did she hear a statement?
Well, you can ask, did you hear a statement, yes or no, but once we get into the content of the statement, it does appear to be hearsay.
Did you hear a statement about the pictures?
yes,
And did anyone remove the pictures or the box from the trailer?
I don't recall.
You
I
don't
don't
recall?
remember them being brought out of the trailer.
Okay. At the time that you heard this statement, who all was present, if you recall?
It was me, Linda. I'm pretty sure that Kathy was there, but I'm not right there in the semi. I think she was down in the shed. And my husband was nearby, and the boys.
And where was Linda Stermer?
She was standing right next to me.
Okay. Can I have just a second, young? Did you make any other visits to the house after you stated that you all had been out there for 3 or 5 days?
I don't recall that, but the 3 days that we spent out there is the only 3 days that I remember.
I have no further questions, Your Honor.
Good morning, Ms. Benny.
Good morning.
So when you met Linda, it was after the fire.
Met her one previous time before that.
Okay, how much time did you spend with her then?
I didn't.
You didn't spend any time?
No, we were introduced, and I went into my house and did my own thing.
So really those 3 days after the fire was your first interaction with Linda Stermer?
Yes.
Never met Todd?
No, I never met Todd.
And you were introduced, or excuse me, I think you said your husband was introduced you to Linda through Kate, correct?
Correct.
Okay, and that was to connect you with the horses?
Yes.
How many horses did you take for Ms. Stermer?
Oh, that's hard to, well, it's not hard to answer. At the beginning, when we took the horses away from her property, after the fire, there were a total of 5.
Did you get more?
Oh, yes.
How many more did you get?
We had a total of 18 horses.
And these were all then Linda's horses?
Yes.
Did you get any more?
After we got the 18?
Yes.
No.
Did you ever have an opportunity to meet Mr. Chris Williams?
No.
Linda ever talk about him?
No.
And Kathy, you said, was with you when you went out the day after the fire, correct?
The day we went through the semi, yes.
And she was there with you as you were in that semi?
She was not in the semi.
Was she by you?
No, she was down the hill in the shed, looking through for tack and what have you that we needed for the horses.
But she was out there with you in going through the items?
Yes.
And you never heard Linda say that she asked the boys or Todd to move those pictures out into the storage area?
As far as I heard one of the boys,
I'm not going to ask you what the boys said. Did you hear Linda say she asked the boys or Todd to move
No.
the pictures out there?
Linda did not say that.
Okay. So if Linda said she said that, Linda would be wrong.
I'll allow it for cross.
As far as what?
If Linda said she said that, Linda would be wrong, right?
I object to the characterization of calling my client a liar.
I think she's saying she was wrong,
Yeah.
so I'll allow it.
Linda never said that. I mean,
I have no further questions, Your Honor. Thank you.
Ms. Benny, where did you,
I just did.
where did you move the horses to?
2 of them went to Kathy Eel's house, and the rest came to my house.
And then did you ultimately do anything else with the horses?
Yeah, we cared for them. We maintained where they lived. We made sure they got fed, stuff like that. Kathy had the same thing. She had 2 horses at her house. She had to make sure they were taken care of, watered, and fed.
Still have the horses?
No, we do not right now.
What happened to them?
Your Honor, I guess that's irrelevant at this point.
Was she-
Talking about things that happened in the next piece.
She asked about.
I'll allow you to ask what happened to the horses.
Did you sell the horses, or do you still have the horses?
No, we do not have the horses.
Okay. Did you sell the horses?
We did not. I and my husband did not sell the horses.
What happened to them?
Some were rehomed, some were taken back to the previous owners, and some were sold.
Okay. I have no further questions.
Anything else, Ms. Seidel?
No further questions, Your Honor.
Jury, do you have any questions of this witness? Any hand going up? I have a question from the jury, ma'am. No objection from counsel. What were the dates that you sifted through the ashes and went through the semi-storage?
Oh, I don't know exact dates, but I could tell you what season it was. It was like not much later than after the house fire, because the horses didn't have any water or any electricity, so we had to get them out of there as soon as possible. It was still snowing, so I'd say mid-February when we got the horses to my house and Kathy's house.
Okay, thank you. Counsel, any questions in light of the question and answer?
No, Your Honor.
Jury, any other questions of her? None, thank you. If she's under subpoena, may she be excused?
Yes, Your Honor.
No objection.
Thank you, you're all done.
Thank you.
Mr. Mueller? or Mr.
Yes, we have witness Mr. Rich McGrew.
If you raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give in this cause will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Please have a seat. Chair's kind of hard to move. And then if you could put the microphone near your mouth so the jury can hear you, and tell us your full name and spell the last, please.
Richard Anthony McGrew, M-C-G-R-E-W.
Thank you. Mr. Mueller?
Morning. Mr. McGrew, can you tell us what you do for a living today?
I'm the village manager of Matawan.
How long have you been in that position?
2 weeks.
Congratulations.
Thanks.
Hope I'm not pulling you away from your job right off.
Right.
Back in the summer of 2024, last year, do you recall getting a file from Kathy?
Kelly Largent.
Yes, Kathy Largent.
Yes.
What was your position at that time in the summer of 2024?
At the time, I was the acting building official for Lawrence Township, and I did get a FOIA request, and I had Kelly Largent go through and pull all the files and the records for that particular job.
Okay. As building director?
Official. Building official.
Building official, what are your duties?
Run the building department. I do all of the building department, the zoning, planning, rental division, do all the plan reviews and the inspections for multiple jurisdictions at that time.
When you say you do the planning and inspections for jurisdictions, would that include Lawrence Township?
Yes.
Right. Did you get a FOIA request, Freedom of Information request from my office?
Yes.
And Ms. Largent got you the file pursuant to your request?
Correct.
Right. Did you review the file?
Yes.
Right. I want to direct your attention, and I think I've opened it up, to Exhibit CC.
Yes.
Can you tell us what that file is, that exhibit?
It was a building permit for the certificate of occupancy for that home.
That home would be located where?
Good question.
If I look at a yellow page and you see the Bates numbers on the bottom right, page 226.
That would be the 66598 County Road 215?
That's correct.
Yes.
What did you understand, or who did you understand that particular file of that address to belong to?
To Mrs. Stermer.
Okay. Are you in a position, or were you in a position back in August 24 to review the building file and look to see if there were final permits, interim permits, final certificate of final occupancy?
Yes.
Okay. Does this file that we're looking at, Exhibit CC, represent the entire file that you were provided?
Yes, it looks like the file that I had.
I'd move for the admission, Your Honor, of Exhibit CC, point 1 and point 2.
No objection.
Court will proceed with those exhibits.
Thank you. There are two separate files in here. Would that be right?
Correct.
And if you look at the first page, kind of refresh your recollection, what are those file numbers?
It should be the zoning file and then the building permit.
What is the difference?
The zoning has to have the approval prior to a building permit being done to make sure it meets all the required setbacks. And then once that's approved, then it moves into the building process.
Okay. In looking at this particular file for the Stermer residence, did you look to see if there were any final building permits pursuant to that, or for that address?
Yes.
And what was your findings in terms of any final permits?
I did find that it had the rough ends all done for the mechanical, electrical, plumbing, the MEPs is what we call them. Those normally have to be done prior to any building rough ends done, mainly for safety issues. And then it looks like there were no other inspections done after the rough end were completed. So it was completed for all the mechanical, electrical, plumbing, and building were all completed at rough end stage. Nothing past that.
So there were no final inspection certificates for electrical?
Correct.
Or mechanical?
Correct.
Or what else is there?
Plumbing.
Plumbing? Nothing for
And then
that either?
building. And then the final one is the building.
Would that be considered or called a certificate of final occupancy?
You do a final inspection, and then once that final inspection passes, then you actually award a certificate of occupancy.
Okay. Was there any evidence that there was a final inspection?
No.
And was there any evidence in your file that that residence for the Stermers ever got a final certificate of occupancy?
No, it did not.
Is that important that people get a final certificate of occupancy and go through a final inspection?
Yes.
Why?
That means that the house was safe, everything passed the building code at that time, and then it's allowed for occupancy. And no occupancy is allowed until you actually have the occupancy awarded to that residence.
What would be the risks in terms of safety if you didn't have those inspections?
If the electrical wasn't inspected and it had a malfunction, somebody got electrocuted, somebody got injured. A lot of times in the case of a house fire or water damage or anything at all, then the insurance company will kick it out and deny the claim because it was not final and safe at that point in time for occupancy.
One of the risks you said is house fires?
Yeah, house fires, we've seen water damage, we've seen wind damage. There's been multiple issues that we've seen throughout the jurisdictions. I've done over 36 jurisdictions and we've had multiple ones.
How is it that a person, a family, could move into a house without having these final inspections, without having a final certificate of occupancy?
A lot of times when a homeowner moves in or actually is doing the permit themselves, if they don't have a contractor, they don't know that you have to call in for a final most of the time. Most of the time it's just, they don't know how the process works. Like the contractor knows you get a certificate of occupancy, that finals your permit, and a lot of times if you're doing it self-funded where you're paying for the the permit or the house as you're going, a lot of the homeowners don't understand that if the building official does not explain that to them.
Not having those final certificates, not having the certificate of final occupancy, is that considered, from a government standpoint, illegal?
Yes, it is illegal.
I don't have any other questions for you. Thank you, sir.
Thank you, Your Honor. Good morning.
Good morning.
Do you live in Lawrence?
No,
Do you live in Van Buren County?
no,
Are you familiar with the size of Lawrence as you work there?
yes.
Would you call it a small town or a big town?
It is a small municipality.
And so, being a small municipality, would you say that a lot of the inspectors know the community members?
Probably not. Most of our inspectors at that time were from Richmond, some were from Athens area, some were from New Buffalo area. So they were from all over.
Do they spend time in the community and work in the community?
Yeah, they're there probably at least once to 5 times a week, depending on how many inspections they have in that area.
And you know when somebody's getting a building permit that obviously a house has started, correct?
Yes,
And you stated here that the plumbing, electrical, and the initial inspections were all done when the house was started.
well, there's multiple inspections. There's from foundation, footing, all the way up to rough in. Then after the rough in is completed, you go to an insulation for an energy inspection. Then you continue on to electrical, all the
The
finals
finals.
at that time. Yes.
So all the initial ones were started
Yes,
and approved.
yes,
Plumbing, electrical,
yes,
structural,
yes,
those were all done. So the township would have known that there was a structure going on, correct?
yes,
And they would have known that the structure was going on when that building permit was applied for.
correct.
So if the house took 6, 7 years to complete, the township would have had all the documentation that that house was under construction.
Correct.
And as your job as a building inspector, do you keep track of what's under construction in your area?
It was doing 36 municipalities at that time. You can't keep track of every single building. And normally the computer after 6 months will generate expired permits and email the permit holders, whether it's a homeowner, whether it's a contractor, and let them know their permit is about to expire. And it's normally within 6 months after the last inspection that they had. So a lot of times that falls back onto the permit holder to renew the permit and to continue on with it.
And you
So-
don't know what happened in this case?
No, I didn't have any inspections. I didn't do anything with this home other than I took over after that inspector had moved on. He had resigned, I think, in July, and then we got this.
Can you agree, it's no secret that that house was under construction for a number of years?
Right, yes.
And in a small town, you were aware, or somebody was aware, they were living there.
I wasn't there.
Speculation as to somebody.
I'll withdraw.
Thank you.
If the building inspector had notice of this home being built and any inkling that it would have been unsafe, would they have taken any action?
We just object, assumes facts, not evidence, asking him to speculate on that.
The way it's phrased, it does call for speculation.
In your current position as a building inspector, if somebody was living in a home and they hadn't received their final occupancy permit, would you take action to remove them if you felt it was unsafe?
I would red tag the house and explain to them that there is no certificate of occupancy, and until you have all the final inspections completed, then you could move back in.
And nobody did that in this case?
I don't know.
Do you have anything in the file to suggest that that occurred?
Nothing in the file shows that any finals were done.
And nothing shows that it was red tagged?
Nothing shows that in there.
Nothing shows that anybody went out to this house and had a conversation with them?
Nothing. Other than obviously the emails from the expired permits. That would have been the only thing that they would have contacted them for. And at that time, it's the permit holder's responsibility to renew the permit or move on. with
And
the
those
file.
emails are in that file?
I'm not sure if the emails are, because it generates off the system. So it automatically sends them that 6-month time, 180 days.
In 2007, was that the case?
That's a good question. I don't know. I wasn't at that company in 07.
Okay. And you don't know what their procedure was at that time?
No, I don't know if they had that same computer system at that time or not, because they did develop the system, but I'm not sure when they actually implemented their computer system.
And you have no evidence that those were set in that file that's been provided today?
No, I haven't seen anything.
Okay. I have no further questions, Your Honor. Thank you.
Just a couple follow-ups, sir. You said if it's expired, it's then the homeowner's obligation, whether
Permit
it's
holder.
permit holder,
Yes.
right? Whether it could be the homeowner, or sometimes if you use a contractor, it's the
Correct.
contractor.
Okay.
If the permit expires and the homeowner says, I want to re-up the permits, do you have to go through the whole inspection process again?
No, you can actually up to 365 days. I normally give them a year. At that point in time, if they had no inspections in a year, then they could go ahead and renew it for a $75 flat fee.
Okay. And not have to start over?
Right, correct.
Bottom line, though, it's the homeowner's obligation to keep up with that. Or I should say the permit holder,
Correct.
right? Okay. And there's nothing in your file that shows that the permit holder, Mr. Todd Stermer, did any of that?
No.
Okay, thank you.
No further questions, Your Honor.
Jerry, do you have any questions of him? At least one hand going up. Sir, I have a question from the jury, a couple questions, no objection from counsel. Did or does Lawrence Township have language on permits stating a final inspection was needed before occupancy permit was issued?
Yes, normally on the building permit, it states what inspections are required throughout everyone that's on that particular job. It'll have a list of inspections that are required under stipulations.
And is there standard language in all townships, villages for final permits per state laws?
Yes.
Counsel, any questions in light of the questions and answers?
Just want to make sure I clarify that last answer. Pursuant to, would be Lawrence Township?
Yes.
All right. Pursuant to Lawrence Township laws and the government, without a final certificate of occupancy, that house is considered unsafe to live in?
Correct.
Okay. Thank you.
I just want to clarify, it's not unsafe, you just haven't inspected it.
No, it's unsafe. It's unsafe until the inspections are completed.
But you didn't document anything that was unsafe, it's just nobody's been out to the house, correct?
Right, and at that point in time, by legal law of the code, it is unsafe until the inspections are completed.
Okay, but you can't say what would be unsafe until you actually inspect it?
Correct.
Okay, I have no further
Right.
questions.
Mr. Mueller?
Nothing more, Your Honor, thanks.
Thank you. Any other questions, jury? No? May he be excused from subpoena if he's under one?
Please, thank you.
Thank you, sir. You're all done.
Thank you.
Go back to your new job.
Enjoy, thank you.
Mr. Mueller or Mr. Kelly, you may call your,
May we approach?
you may. Okay. Mr. Mueller, did you have any further?
1 second, Your Honor, so I can just. Your Honor, by stipulation of counsel, we have agreed to admit plaintiff's exhibits AA and BB, Alpha, Bravo, Bravo, medical records of Dr. Yu.
Agreed, Ms. Seiderman?
Yeah, I just wanted to take a look at both. No, Your Honor, I just wanted to take a look at, we agree, it's just what he was prescribed in his medical records for the ear infection, so we agree, that's fine.
Okay. So I'll admit, what is it, UU and
Okay. Oh, UU
you?
and AABB.
Okay, we'll admit those by stipulation. And any other witnesses, Mr.
We don't
Mueller?
have any live witnesses, Your Honor. We don't have
Okay, no witness. Your rest?
No, Your Honor, we need to put something on the record.
Okay, okay, outside the presence.
Right.
Got it. And Ms. Seiderman, did you anticipate any rebuttal?
No, Your Honor, we have no rebuttal witnesses.
Okay, thank you. So jury, what I'm going to do is, we're getting near the end here now, so we're working on final instructions and things like that. That's why we had a late start this morning. But I'm going to have you go and come back to the jury room at noon and go do whatever you want to do, but you're still under all the instructions of the court to not discuss the case or do any research or media searching. And then we'll get you some lunch back here. You can anticipate having some pizza or some lunch back here. And I think George is aware of dietary restrictions, but if you have any, you might want to let him know ahead of time, okay? So back here to the jury room at noon, and I anticipate at that point we'll be going right into closing arguments. Okay, thank you. Okay, counsel, the jury has left. And Mr. Mueller, you wish to place something on the record? You may. You may.
Wait for the jury to leave.
Okay. wish to place something on the record?
Yes,
Or,
Your
I'm
Honor.
sorry, Mr. Kelly?
Yes, Your Honor. On behalf of Ms. Linda Stermer, we have explained to her her constitutional rights in reference to her right to testify in this case. And she fully understands that she has a right to testify and that she's waiving her right to testify as it relates to participating as a witness on behalf of herself. And so to that extent, Your Honor, we would, if you have any questions you would like to ask of Ms. Stermer or to me, we're prepared to respond.
So, Ms. Stermer, you've been advised that it's basically, it's your call on whether or not to testify in a criminal case. And so you've discussed this issue with your lawyers? And,
Yes.
okay. Do you have any questions about it?
I feel that I'm fully advised of my constitutional rights and have decided to waive my right to testify.
Okay. And you're certain about that?
Yes, ma'am.
Okay, thank you.
Yes,
I don't have
ma'am.
any further questions of counsel or her. I don't know if,
I don't either, Your Honor. Thank you.
okay.
Thank you, Your Honor.
Thank you, counsel. Anything else, counsel, to address before we reconvene to go through finals again?
People have nothing, Your Honor.
We rest, Your Honor.
Okay. Defense rests, thank you, and the prosecution has rested.
Yes, Your Honor.
So counsel will meet, maybe can you come back in 10 minutes or so? We'll go through the finals again.
Yes, Your Honor.
Okay. Does that work?
10 minutes?
Yeah, 10 minutes back in my office. We can go through another round of finals.
Yep.
10, yep.
Judge, I sent the quarter case as well as opposing counsel about the second-degree murder issue.
Okay.
Just if you want to take a gander at it, I emailed it to everybody to look at, just so we have a, I think it resolves one of the discussions we had back in
Oh, good, okay. I'll have a look at that. Okay, I'll see you all in 10 then.
Thank you, Your Honor.
Thank you. Okay, we're on the record in the case of People versus Linda Stermer. The jurors are not present. They're in the jury room. The record should reflect I've met on 2 occasions now with counsel to go through final instructions. And at this time, I will place on the record the instructions I intend to provide, and counsel can then indicate if I'm wrong in any way based on what we discussed, or any objections you can place on the record too. So I'll be providing 3.1, duties of judge and jury. 1 minute, counsel. 3.2, presumption of innocence, burden of proof, and reasonable doubt. 3.3, defendant not testifying. 3.5, evidence. 3.6, I'm sorry. 3.4, what's, I don't have that in mind.
3.4?
I don't have one. Okay. I don't have that in the list. I don't know offhand what that one is, but. Are you just mentioning that because I skipped a number? Or,
Yeah, because we just got the new.
okay. Did,
3.4 is impeachment by prior conviction. We had none of that.
oh, so 3.4 doesn't apply? Okay. 3.5, evidence. 3.6, witnesses' credibility. 4.1, defendant's statement against the defendant. 4.3, circumstantial evidence. 4.5, prior inconsistent statement used to impeach a witness. 4.7, stipulation. 4.9, motive. 4.10, transcript of prior testimony. 4.16, intent. 5.2, weighing conflicting evidence, number of witnesses. 5.3, witness who has been interviewed by a lawyer. 5.10, expert witnesses, and that single instruction applies to all those who testified as experts in this case. Demonstrative exhibits. 5.11, police witness. Then we move on, counsel, to the elements of the offenses. Initially, I'll note that after discussion with counsel, it's my understanding that counsel are in agreement that as to counts 1 and 2, the jury will be provided with the option of the lesser offense of second-degree murder. Is that correct, counsel?
That is correct, Your Honor.
Yes, Your Honor.
Okay. And no one has requested manslaughter instruction of any sort. Is that correct?
I am not, Your Honor.
Am I correct, Mr. Kelly, that there's no request for a manslaughter instruction here? Is that correct?
Yes, Your Honor.
Okay. Okay, so elements of the charges, count 1, and then we're including the lesser of second degree. Count 2 elements will be provided. Felony murder, again, on that count. After discussion, we will be providing the lesser of count 2 on that one. Time and place venue. 16.21, inferring state of mind. 3.11, deliberations and verdict. 3.13, penalty. 3.14, communications with the court. 3.15, exhibits, and we're still awaiting some of the defense. And exhibits, counsel will need to get defense. I think we have all the prosecutors, but you will need you to gather up the exhibits that have been admitted.
Your Honor, we do have a tote sitting behind me then of all the physical evidence.
Okay.
So if the jury, or we'll turn it over to the custody of the court.
Yeah, we'll get it in the jury room. So as soon as possible, once we're done with closing arguments and we get the jury in the jury room, if you could help us figure out where your exhibits are so we can get those to the jury. Written instructions, 316. Single defendant, multiple counts, more than one wrongful act, 320. Verdict form, 323. Counsel have been provided with the verdict form we intend to provide to the jury. The record sure reflects, too, we did have significant discussion about the unanimity instruction, and I think everybody came to the conclusion that the way the charges are presented, that it was maybe more confusing than anything for the jury, so we're not providing that instruction. Is that a fair summary?
Just that we're providing the standard instruction. I think what we talked about is that we took away the unanimity instruction that we thought pertained to open murder, but we kept the standard unanimity instruction for both counts.
Correct. Is that your understanding, Mr. Kelly?
That's correct, Your Honor.
Okay. So counsel, and you both have I know we talked about a couple different verdict forms. You both have the final one we intend to use for approval?
I have the one that we discussed. I don't see
Okay.
one attached in here. If it's the same one that was discussed prior to our break, or at our break, then I do have it.
Okay, it is that same one.
Okay.
I thought I had a copy here.
Let's see. He might be back at his desk. One moment, we're going to gather that form just so we're all looking at the same item. While I'm waiting for that verdict form, to the media who's here, there's going to be a point where we release jurors. So I would prefer if you could not film that part when we're releasing the alternate jurors in the case, okay? And then if you want to, I think after that we'd just be doing, and then after that we're pretty much sending the jury off. So, but there's your heads up. I don't know if it's just a click or what, but. While we wait for the verdict form, Mr. Mueller or Mr. Kelly, did you have objections to the ones I intend to provide, or did you have special instructions or other instructions you're requesting?
Yes, Your Honor. As we noted, we requested a spoliation instruction, adverse inference instruction with respect to the in-car video from Deputy Russ, which was shown. We showed in plaintiff's exhibits 10 pictures taken over 9 seconds. Deputy Russ said it was from his in-car video. He didn't know where it went. The prosecutor apparently didn't know where it is. It's never been turned over to us. Our argument is that clearly a video is way better than 10 pictures over 9 seconds in terms of showing in real time the progression of the fire. As the court knows, one of the big issues in this case is the speed of the fire, where the fire was located initially. So we think because it's the obligation of the prosecution and the sheriffs through the prosecution to turn that over in discovery, we've been hamstrung by that, we've been prejudiced by that, and we would request an adverse inference instruction that had it been produced, it would be disfavorable to the prosecution.
Thank you. Prosecution response?
Your Honor, what I can say is this, because this is kind of encompassing a discovery issue as well that I think we've actually talked about before. This video back in 2007, and if we have any question about that, actually Detective Romeo here could speak to that as well. They use VHS tapes in the patrol cars. I understand Mr. Russ maybe not have been very clear on that, but they use VHS tapes that were reused and recorded. I can speak to that. Even in 2009, when I started here, VHS tapes were used because I used to get them in cases. And unfortunately, those tapes were reused and were sometimes corrupted and didn't work properly or whatever. My understanding is these stills were taken from the videotape because the videotape itself was not in good working order. And that's why we have where we're at this point in time. They are a representation of what was on that videotape. It is all we've ever had in our possession since we took over, Ms. Zyderman and I took over this case, and even prior to that, the original case file that we had in our office never had that videotape. I've been through all the evidence of the Sheriff's Department. There are other VHS tapes present there of different interviews and things, but this videotape has never, ever been located. All we've ever had is still photographs, which have been turned over as part of evidence. In the case from the onset, there is, I don't think there's any justification for a spoliation or an adverse instruction against the people. There's no legal justification, no case law in support of this, and I don't think it's appropriate for the court to give such. Thank you.
Thank you. And I think you were indicating those were, instead what you have are these 10 photos that were taken
Yes.
over how many seconds?
9 seconds.
9 seconds. Okay, the defense is requesting a special instruction as it relates to this video. The court finds that I'm not going to provide the instruction. The defense has not demonstrated to this court that the government acted in bad faith in any way in failing to preserve the evidence, or that the nature of the evidence was such that the defendant would be unable to obtain comparable evidence by other reasonably available means. The court is citing People v. Kress reversed on other grounds. If the court uses the missing witness instruction, then the issue is whether the prosecution exercised due diligence. But in any event, under either standard, I find that the defense has not met its burden to get the instruction.
May I give a 30-second response, Your Honor?
No, thank you. And counsel, in the meantime, did you get the
I've not seen an
Okay.
email.
Oh, it should be on the verdict form?
We have a written one, but I don't.
Oh,
have
you
one.
want an email?
Yes,
Okay.
and he said he emailed it, but there's nothing coming up.
Can-
You want me to forward that email to you, Wolf, that I got?
Please.
Oh, wait, Jay might be on the case here.
Yeah, it was sent to all of us.
It's not on your emails?
I have it.
We just,
Okay.
he just.
I just forwarded it to Mr. Mueller. Hope maybe it was a.
And this is the one do you have it yet, Wolf? On your email?
I don't have
Oh,
the, I think
you
Joe
just
was
need it on
email
your-
it, said he emailed it, but I haven't seen it.
Okay. So I think Jay just sent it to you, because you need it for your closing, right?
I'd like to have
Yeah.
it loaded up. No, I'm going back to before noon, Your Honor.
No. I think Jay's going to try to get
I
it
did.
to
I
you.
just emailed it.
Here we go. Here we go. I got it.
Okay.
Defense, are you good with the form of the verdict form, providing the option on each count of not guilty, guilty of first degree, or guilty of the lesser offense of second degree?
Yes, Your Honor.
Okay. And I know, Wolf, you're waiting to get your,
Just 5 minutes real quick.
Okay.
I got the email. I'm just trying to,
you put it into your
please.
PowerPoint or whatever, okay. The jury has pizza, so they won't mind.
Thank you, Your Honor.
You good?
I'm good. What's that verdict?
Do you have what you need, Mr. Mueller? Are you good?
I'm good, thank you.
Okay. Anything else, counsel, before we bring in the jury for closing arguments and final instructions?
I have nothing, Your Honor.
Anything else, defense?
No, Your Honor.
No? Okay, we'll bring in the jury. Welcome back, jury. As I indicated, we are now at closing arguments. Ms. Siderby?
Good afternoon. First of all, I want to take this opportunity to thank you for your time and your attention over this very long 3 weeks. It's obvious you've been paying attention, and the questions were very thoughtful questions, and we appreciate that. So, what is the closing argument? Closing argument is an opportunity for us to rehash what you've heard, kind of condense it down. It's been a lot of information, a lot of witnesses, just a chance for us to summarize. And it's also a chance for us to give you our theory, what we think happened. So let's jump in. We talked in the beginning, I think in our opening conversation, about the two charges. We have a first-degree murder and we have a felony murder. 2 counts. That's what you're going to be deciding and looking at. So, again, going back to the boxes that I have to check. That's what we talked about in voir dire, right? Those boxes, those elements. So, you can see on the screen what the elements are. Defendant caused the death of Todd Stermer. Defendant intended to kill Todd Stermer. That the intent to kill was premeditated or thought out beforehand. And that the killing was deliberate. There's some definitions there, which you will have. The judge will give you all of this in writing, but that's really breaking it down to the simple form. Let's take a look at count 2. That's your first-degree felony murder. 3 boxes I need to check. First, that the defendant caused the death of Todd Stermer. Second, that the defendant had one of 3 states of mind. She intended to kill, or she intended to do great bodily harm to Todd Stermer, or she knowingly created a very high risk of death or great bodily harm, knowing that death or such harm would likely be the cause of her actions. And third, that when she did this, when she caused the death of Todd Stermer, that she was committing or attempting to commit the crime of arson. So those are your 2 counts. But within that, we need to take a look at arson, because that's part of that last element. So what are the boxes for arson? That the defendant burned a building, that at the time of the burning, that the building was a dwelling house, was a residence. Third, that when the defendant burned the dwelling, she intended to burn the dwelling. And again, there's a little bit more description there, which you will have a copy back in the jury room. But that's broken down simply. Those are the boxes. So, let's talk about the evidence that you've heard now for 3 weeks. Because every witness is only one piece of this trial. You are the fact finders on whether these crimes were committed. And it's taking all of the evidence into account. So let's take a minute to look at the evidence. First of all, you heard from Sandy Stermer. She's the mother of Todd Stermer, victim who died in this case. Todd and Linda were not in good financial standing. You heard lots of testimony about that. The loans, being behind on bills, never able to pay the bills. Sandy talked about how Todd was in good shape. He was an athlete. There was discussion about how he was a coach. Todd built that house that burned on January 7th of 2007, and Sandy described her son as a perfectionist. Linda relayed little detail or facts about that fire to her in the stories that she ever gave Sandy. Twice, Linda said she went out the basement door, and once she said she exited out the front door. you next heard from Tony Evans. Tony, Deputy Evans, was the first deputy to arrive on scene at that residence on County Road 215. He observed the Stermer residence to be on fire. Flames were coming out the second floor and the smoke was going up. It was an overcast day. No issues traveling down that driveway. Hadn't started raining by the time he got there. Found Todd Stermer laying on the north side of the house. So as you're looking into the house, to the right-hand side. He was badly burned. His skin was slipping off his hands. Defendant was laying on top of him. He described it as face-to-face. And he had to physically remove the defendant from Todd Stermer's badly burned body. Todd had lacerations to his head and to his back, which you have then the autopsy, a copy of that, as well as pictures. His pants and his underwear were down to his ankles. Had his socks on. Deputy Evans used a plastic, he described it as a plastic molded sled to move his body to a safer location because of that fire, that fuel tank by the house. That was the fuel tank for the furnace. And when he was on the property, that's when he noted a van still running, smoke coming out of the tailpipe, parked in the rear of the residence. And that's when he saw the blood that you have the picture of, and he put a flag on. Tony took several photographs, of which we put several up for you, and they are admitted into evidence. He was able to follow a set of tracks. And he marked them. You can see you've got the left tire here, and you've got the right tire here. Same here, you've got the right tire and the left tire. He's able to follow that set of tracks through the area, right through where Todd was originally located. Those tracks led directly to the van that was running. You heard from Deputy Gruss. He was the second deputy to arrive at that Stermer residence. He arrived to the residence fully on fire. You can see by the picture what he saw. He attempted to render aid to Todd. He also observed Linda laying on Todd. He also stated he saw Linda's hands on Todd's face. He assisted in moving Todd and performing that aid on his badly burned body. He had an opportunity to speak to Linda Stermer, the defendant. Her statements at that time, where she was downstairs doing the laundry, heard Todd yelling and screaming, ran upstairs to the main level, and it was full of smoke. She was yelling for Todd. She tried to go up the stairway, but could not get through the fire. So she ran out the front door. Later, she saw Todd in the yard. She got in the van, and she drove around to try to get Todd help. You then heard from Dr. Musali. He testified that he was one of the neighbor to the Stermer residence. He saw the fire and he drove to the residence. I believe he said him and his sons were outside doing some chores. They got in a car, drove down to County Road 215 and drove up the driveway. He also discovered Todd in a badly burned state. Todd was laying near the house. He also said Linda was laying on Todd. And he helped move Todd in what he described as a small plastic John boat. And he also attempted to perform aid on Todd. You heard from Annette Crandall, a friend of the Stermers who responded to the scene as soon as she saw the fire. She sat with Linda at that scene, and she then said that she talked to Linda days after the fire, and Linda had told her that she picked Todd up and leaned him against the front bumper, and that's why there was blood on the van. You heard from Steve Leach, also a neighbor of the Stermers. Saw the fire, drove to the residence, lives right by it. He also described how badly burned Todd was. He also talked about how Linda had to forcibly be removed from Todd, not once, but on 2 separate occasions. He talked about how he attempted to render aid to Todd's badly burned body. He talked about how he helped move Todd away. And he stated, actually he was the Lawrence fire chief at the time, that he smelled fuel about Todd's person. You then heard from Mike Matheny, the direct neighbor to the Stermers. He testified that he was leaving his residence around 3:30. He went bowling at 4 o'clock on Sundays. He drove to the Stermer residence, and this is key. When he drove into the residence, he saw Linda in the van in the driveway. So we've put up a drawing here. You're coming in this way towards the house. He's coming towards the house, and he sees Linda in this area. And he says, as he's driving down the driveway, what does he see? He sees her back up the van and immediately drive to the north side and around to the back of the house. He stated he parked his own vehicle, went down behind where he saw the van going, and shortly after, as he's approaching, he sees Linda out of the van walking away from the van. He kept asking for Todd's location. Where's Todd? Where's he at? And Linda finally said, there he is. Todd was unclothed when he saw him. He ran to his vehicle to gather some clothing to cover Todd. He talked about describing some of his items that he had, some hoodies, some coats, of which then you'll also see physically. You have the physical evidence of it, and it's talked about in lab reports. He helped move Todd away as well from that location by the fuel tank. You heard from Connie Calhoun in her emotional state. She also testified, she was living with Mike Matheny at the time, that they had bowling on Sunday at 4, and she left about 3:30 out of their residence. And when they were leaving, they saw the smoke when they left their house. She testified that she drove up that same driveway as a passenger in that vehicle with Mike Matheny, and she saw Linda in the van. She stated Linda's van was facing out towards the road. As they're driving down, Linda's driving out, they're facing each other. She then stated Linda's van then turned around and went to the back of the house. She got out of the vehicle, and the next time she went up, she saw Linda laying on Todd. You heard from Kim Thompson, Kim arrived at the scene of the fire. She's a friend and a neighbor to the Stermer family. She was just trying to go and help. She saw Linda for the first time that day on the hill on the north side of the house. Both the family dogs were outside. I think she told you about how they had to try to help catch the dogs a couple different times, or at least one of the dogs. Linda told her that she heard Todd yell, "The house is on fire." Then Linda opened the door, opened that basement door at the top of the stairs, and went outside, and she didn't know where Todd was. Another story that Linda told Kim was that there was a kerosene heater located near where Todd's chair was in the living room. In a third story, Linda claimed that Todd may have fallen asleep and dropped his roach. She told you that she took possession of both of those dogs and cared for them after the fire. You then heard from Ken Thompson, her husband. He remembers it being an unusually nice day for that time frame in January. He'd been out cutting wood across the street, spent most of the day there. He had gone past the Stermer residence 15 or 20 minutes before on his way home after cutting wood. Said he didn't notice anything out of the ordinary. Got home, heard about the fire on the scanner, and he immediately got in his car and went back to the Stermer residence. Todd was on the north side of the house when he arrived, and he again described the injuries that he saw. Linda told him that she was downstairs doing laundry, looked up the stairwell and saw fire, too much fire to go upstairs, and she ran out the basement door. You heard Dr. Michael Markey, the forensic pathologist. He talked about how when he received the body, that Todd's body had the socks, the two socks, the underwear, and a shirt across the groin, and that's in the report and detailed in the report. He preserved those items and turned them over to law enforcement. He, as a doctor who does autopsies, had no opinion as to how the blunt force injuries occurred, other than Todd received blunt force trauma. And he described what he looked for and why he made that determination, and how he looked for particular patterns and didn't see them. And so all he could say was a blunt force trauma where the skin splits. Didn't know if the injuries happened before the fire, after the fire, or what caused them. He also couldn't tell the order of the injuries, just based on the body and looking at the body and examining the body. Couldn't tell what injury occurred first. He said that the burns to Todd would have caused severe pain. And that's common sense. When your skin is slipping off your body, that it would be painful. He also talked about the toxicology, which is on this bottom area here. Oops, sorry about that. He talked about the toxicology and about how in the blood they found caffeine, and it was negative for other substances that they screened for. And then in the urine, he found the hydrocodone, hydromorphone, and it was negative for anything else they screened for. And what's important to remember is he couldn't quantify the amounts. He could only tell you that they were above the amount that they screened for. We don't know how much of that drug was in the body. He also talked about 4 distinct lacerations in the head. He talked about 1 on each side, 1 on the top, and 1 in the back. And that's also in his report. He did say, upon questioning, and agreed that it would be consistent with injuries from being hit by a van. And he also said that the lacerations would be consistent with being hit by a blunt force object like a frying pan. You heard from Mr. Jim Shinsky. He gave the first detailed interview, or conducted the first detailed interview with Ms. Stermer about the fire. We talked a lot in voir dire about what do you do when you have inconsistencies? How do you get to the truth? What do? You start asking more questions. We talked about it in voir dire. Those were the answers you gave me. I ask more questions. It helps me get to the truth. One juror in voir dire, I asked a specific question about, well, what do you find when you start asking more questions? Their answer was, well, sometimes you get blame shifting. Sometimes you get blame shifting. Mr. Shinsky conducted detailed questions, started to dig into the inconsistencies. Linda discusses the morning of the fire, and she gives details about seeing that fire and events that lead up to that fire. And there is a transcript of the interview that you have, the entire transcript to review while you're deliberating. This is where she begins to point blame at Todd. I'm not going to bore you with the entire transcript, but I am going to give you a 2-minute recitation of the high points. Filled up the blazer, came home, he got up. She gave him receipts. He got angry and was screaming at her. Went downstairs and woke up boys, told them to go to the mall because her and Todd needed to talk. Went upstairs and made Todd breakfast. He ate and took meds, and they didn't discuss much more. He sat down and started watching hunting program in living room. She did some laundry and some dishes, came upstairs and read an acne instruction booklet. Must have fallen asleep. When she got up, Todd asked for juice. She took him more medication. I told him I was going downstairs to do laundry. Todd was yelling at me, and then all of a sudden she heard him scream. She went running upstairs. There was fire from our bedroom to his recliner. He was on fire, his whole upper body, and there was fire and smoke. I just turned and ran out the door. She jumped in the van to go to Mike and Connie's. She backed up and saw Todd in the yard. She got out to try to help and get fire off of him. Later in the interview, he was screaming. We had been arguing quite a bit. We were arguing over me leaving to go to my sister's. Told the boys we were going to be talking about a lot of things. She didn't know how much arguing or yelling Todd was going to want to do. Just asked them if they would just go, and I would let Dad know that they were going. They didn't come up and talk to Todd because he was all angry. Todd was taking prescription meds, her sleeping pills, muscle relaxants, pain pills, a lot of things lately, and smoking pot too. Further, Todd took meds, began watching hunting. She went down and did laundry, folded laundry, and was putting Christmas ornaments in boxes, was puttering, went back up, read acne med pamphlet, dozed off, heard Todd in the basement. When she got up, he was back in the recliner, asked her for something to drink. Got him something to drink, did dishes. When she came up, made him a fire. Todd yelled at me once during the day and told me nobody else would ever have me. Now, when you came upstairs, you said you could hear him yelling, this is Shinsky, and then it turned to screaming. What was the yelling? She said, that's when he was yelling at me that nobody else would ever have me. When she came upstairs, around the corner from the stairway to the living room, there was a lot of fire between our bedroom door and his recliner. Todd was closer to the bedroom. There was just fire and a lot of smoke. There was no fire on the kitchen and dining room side. She could see Todd's legs. The chair was on fire. There was a little fire on the floor. A lot of fire over by the bedroom. She ran out the front door. She doesn't know where he came out. When he came out, he was completely covered in fire. When she came out, it was just black. She ran towards the side of the house. She saw a bunch of smoke. She ran to the van. She backed up and saw Todd, so she pulled forward real quick and jumped out to see if she could help him. He wouldn't lay down. He was trying to pull his pants and his socks off. She screamed at him to lay down. She got back in the van. She couldn't get the van back up because it's so muddy. Pulled over to try to help him. Realized she couldn't and she had to get some help. Jumped back in the van, but couldn't get back up. Usually we go down to the driveway because it's real sandy right in front of the house and then get going real fast and get back up. But then she saw Todd laying, so she jumped out of the vehicle and she ran to him. He wasn't on fire anymore. She saw the neighbors come up. Then when I was laying on him, I was trying to keep his mouth open and keep him breathing. They pulled me away from Todd. Later, recliner was all on fire. Big bunch of fire by bedroom door and between bedroom and fireplace. Bunch of fire by the recliner, not much fire in between. Ran out to van, parked in front. The keys were always in the vehicles, Todd does. She always brings hers in and puts in the kitchen. Todd was in the side yard. She pulled the van up real quick and jumped out. She was screaming at him to lay down. He was trying to get his pants off. She kept trying to get up and reach and grab him, his pants. He wouldn't stay still. Then he laid down. She jumped back in the van and tried to back up. She couldn't back up because it was too muddy. Couldn't see Todd when she backed up. Pulled down here because I was going to try and back up to get a running start, and she couldn't. Jumped out, ran to Todd. He was laying. She just laid on him, laid on Todd, trying to keep his airway open. She could tell he was breathing. She ran up almost to the fireplace, and fire came from our bedroom direction towards me, towards the fireplace. So it wasn't the fireplace. Her words. So it wasn't the fireplace. He could not have had fuel on him. I took him juice. I would have smelled it. Oh, since last winter was the last time we used kerosene. You think smoking's the cause of the fire? No, definitely not. We don't even own ashtrays. The kids were everything to him. This is where she begins to blame Todd. This interview greatly differs from the one that she gives Steve Willison 1 month later. Mr. Willison was the attorney hired by Farm Bureau Insurance. He conducted what's called an examination under oath of Linda Stermer. The interviews were conducted in February of 2007, 1 month after the fire, and then again in October. Many statements blame Todd for the trouble, more blame shifting. Stories are more elaborate and more dramatic. These statements also greatly differ. Let's look at the February interview. Finances were the wedge. Todd not running his business as well as he could. And she felt he should work more. He was not putting in enough effort, in debt continuously. What other issues were in the marriage, he asked. Horses. Had 49 at one time during the marriage. Said he was addicted to sleeping pills. Saw him take one the night before the fire. What was it? Ambien CR. Night before the fire, he came in the bedroom and tried to pry her legs apart and take off her pants, but she wouldn't let him. Said if he tried to make her, she'd call the police. Got home that day and began cooking and put on coffee for Todd. Told him that she used his debit card. Todd was mad, and she told him, "You knew I didn't have any money to get any of this stuff," when she got back from the gas station. "You wanted me to take care of these things, but I didn't have any money. So I used your debit card again. I spent a total of about $50 to $60 that weekend." That night, she went downstairs to the basement the night before the fire. The boys were watching TV. She laid on the couch with Trenton and fell asleep. They snuggled, because they're a snuggly family. She said she spent the night in the basement, the night before the fire. That's when Willison asks, "Well, what about him forcing himself on you the night before?" And she says, "That was later, after the kids had gone to bed, and then I went up to brush my teeth. He wanted to talk some more then. I told him no, and I went back down to the basement, and I slept on the couch." She tells Willison she told the boys to call before they came home because she needed to get the blazer for them, and she didn't know where she would be. She told the boys to call her before she came home. She had to pack. She went back upstairs and gave Todd breakfast. She made plenty of food, but didn't want the boys to eat there because of the way Todd was yelling at her. Told them to leave through the basement sliding doors. Willison says, "So he tries to force himself on you, and then you get up and get groceries for him and make him breakfast?" She says, "I thought I was making for everybody." Then she goes down to the basement. She packs up Christmas ornaments. She does the dishes. She says now for the first time she begins to pack a suitcase. She went upstairs to get things out of the bedroom, and that's when she sees Corey's booklet about acne medication. She reads the booklet and falls asleep. She gets up, comes out. Todd asks for juice. She gets some juice. Goes back downstairs. When I went back down, he was screaming at me again. He screamed that no one else would ever have me. And so what did she do? She slammed the door in the laundry room. She's taking the laundry out, and that's when she hears a scream, and she runs upstairs and sees the fire. She says, "I saw Todd take 2 Ambien last night." After she gets juice, Todd's ranting upstairs, and then it turned into a scream of pain. She looked in the living room. She sees Todd on fire. Fire was on both sides of him. It was on the floor over here to his chair. To make sure. His chair and the half wall were on fire, but not the whole half wall. His upper body was on fire. He was wearing sweatpants. I know he had socks on. I remember seeing his gray sweatpants. I just screamed and ran. "I've got to get out of here." She jumped in the van to drive to the neighbors. "What did you do when you got in the van and backed up?" She said, "I backed up straight. Where did you see Todd?" And she marks the X of where she sees Todd when she first gets in the van. She's in the van and marked an X of where she sees Todd. When she sees Todd at that X, he was on fire. She was in the van facing the front door. She did not see where Todd came out. She was going to turn around, but backed up. She didn't back up very far, and that's when she saw Todd. So she pulled up and stopped the van at number 3, which I believe Mr. Willison said she originally marked this number 3, crossed it off, and then wrote the one on top. So she pulled back up after she sees Todd, stops at number 3. I drove up there real fast. I jumped out at number 3 and screamed to just lay down. He was screaming and trying to pull his clothes off. I tried to get close to him. He was jumping and moving. He wouldn't lay down. I was afraid to touch him. So she jumped back in the van, and she couldn't get it to go backwards. So I slammed it into gear, and I went forward, and I almost ran through the fence. And that's what she's marked, ladies and gentlemen, as number 4. So the fence, you recall, is on the side of the property, and I believe you have a drawing showing how many feet that fence is from the house when they did the overhead. Now she almost hits the fence. I almost ran through the fence. I thought if I could get down, because every time we've ever had a hard time anywhere in this driveway, we just come down here because it was sandy and better traction. She could floor it and get back up and get to the neighbors. She got to number 5, which was here. Number 5, so she moved to 5, so she's at the fence, moves to number 5. And that's when she decided she needed to go behind the house. Then she hurried and drove to 6, which is behind the house, and saw Todd. He was not on fire. She ran to him. He didn't have his clothes on and was badly burned. He was like pink melt. She ran to him. When she was close, she saw Mike and Connie. She was screaming, and she laid on top of him. She was laying on him because he was naked, and I didn't want him to not be able to breathe. She said, I could feel his heart beating. I could tell he was breathing, but it was hard for him. So I put my mouth on his mouth a few times, and I just tried to give him little breaths. She saw Todd's skin was melted. She threw her purse in the van while she was talking to the boys as they were leaving. She talked to them on the way out because she had turned water on in the horse tank, told them to hang on a minute, not to take off without her purse, went out the basement door with them, put purse in the van because she thought she'd be leaving in the van. The fire was not connected to the fireplace. That's February. October is a small pack. October had already received $93,000 or $96,000. What was the issue you needed to get away from? His lack of working as much as I thought he should be working, getting behind in the bills. You described pretty heavy fighting Saturday night. She says, I don't recall that it was heavy fighting. I know we argued some. Willison says, didn't he try to rape you? She says, no, he didn't rape me. He wanted to have sex. She says she was in the laundry room. Todd was screaming, no one else would ever have me. Then he let out a terrible scream. She ran around the corner of the living room. Todd was on fire. Fire went from Todd to the bedroom. Got in the car, thought she was going to the neighbors to get help. She went through the yard by the barbed wire fence. She couldn't get going and get out of that spot, so she needed to pull down the hill to where there was better traction. She saw Todd before she got to the barbed wire, pulled away from the fence a little and got stuck. When she puts van in forward, she knows Todd's outside. She pulled forward down to the bottom by the house, by the slider. She was going to turn around and come back up the hill, going to try to barrel back up the hill, but sees Todd. First time she saw anyone other than Todd was at the bottom of the hill, either running to Todd or still in the van. She saw Mike and Connie at the top of the hill. She remembers backing up and seeing Todd outside. Got out of the van, screaming at him to lay down. He wouldn't lay down. He was trying to take his clothes off. He wouldn't listen. So then she gets back in the van, floored it too hard. She went too far off the driveway, stopped at the bottom and didn't turn around and came back up because she saw him laying on the ground. She ran to him. She saw the neighbors there. He didn't talk, but he was moving his mouth. He was still alive. He was having a hard time breathing. She remembered breathing into him a few times. They lifted her away. That was October. There's multiple inconsistencies, some consistencies. There's many different statements that blame Todd and point to this blame shifting. The stories are more elaborate, and the statements differ from the ones given to Shinsky. You then heard from David Hayhurst. He's from the Michigan State Police Crime Lab, and he conducted the examination of the van belonging to Todd Stermer. He noted that there were several red-brown stains on the front bumper and the underside of the van. He actually took samples, L1 through L6, of 6 different locations on that van. Said started from the front and went towards the back. All of the locations were then on the driver's side, and they were all on the front-facing parts of the vehicle as he went back. He took samples from all those stains, and he determined them, after testing, to be human blood. You then heard from Ann Hunt, who took those samples and tested a few of them. They're in the report of which one she tested, the locations that they came from, and they matched the DNA from the DNA card taken at the autopsy of Todd Stermer. You then heard from Troy Ernst. He tested the socks, the underwear, the sweatpants, the shirt across Todd's groin area that went into the body bag. And what did he find? Those tested positive for gasoline. He also tested all of the other clothing that you heard from testimony that was placed on Todd. That was Mr. McTheney's. That was put into a separate bag. I believe Detective Maziowski talked about a clean garbage bag. He tested those items, and those are in his report, and those tested negative for the presence of gasoline. And when I asked him about would it be more likely from one of those to then transfer to the other, he said that due to the nature of the particles on the sweatpants, the socks, the sweatpants, the socks, and the underwear, and the difference in the testing that he had done, I believe he described it as lighter and heavier particles, that it would be more likely the transference would have happened in the body bag from the sweatpants, socks, and underwear to the shirt, based on his testing of those particles. He was not able to quantify how much gas was on any of these items. He could only tell us that there was gas, the presence of gas. And he also told us that there was the presence of gas in that gas can, which he also tested. You heard testimony from Detective Rout. She was the detective called to the Stermer residence that evening of the fire. And she also took statements from Linda the night of the fire. Linda talked of an argument that occurred that morning of the fire. She detailed that the argument was over finances and her using a debit card. She had the boys leave to go to the mall so they wouldn't hear arguing, and said no further arguing occurred after the boys left the house. After the boys left, she went outside to turn on water for the horses. She went into the bedroom while Todd was watching TV to read acne pamphlet. Todd was watching TV and she was going to read the acne pamphlet and fall asleep. Woke up, Todd asked her for juice, of which she brought him. She then stated that Linda went downstairs to do the laundry, let out both the dogs and the cat. Not sure where the cat was or why she remembered a cat. Straightened up a bathroom, was in a laundry room and heard Todd scream that there was a fire, ran upstairs, saw a fire in the living room and a lot of smoke, but could not see Todd. And she left the residence, got in the van, heard a boom, and saw Todd on fire on the north side of the residence. Todd was on fire trying to shed his clothes. Then she stated she lost sight of Todd and drove around the north side of the residence to the west side near the basement to either get help or get Todd into the van. Todd was on fire. He wouldn't stop moving. She denied that she ever grabbed Todd. He was burned and gasping, and she was trying to keep his mouth open. Eventually, Connie, Mike, and Dr. Musali arrived, and she stated that there was a fire going in the fireplace. Detective Tom Maziowski testified. He was also another detective called on the scene the night of the fire. He arrived at scene, he contacted other officers to get details. He observed the person of Todd Stermer. He noticed the significant burns and the lacerations to his head. He also noted that Todd's person smelled of fuel. He collected the clothing taken off of Todd, and he attended the autopsy and also collected those items. Remember, the item that Sergeant Leroy collected are the sweatpants. Detective Maziowski collected the other evidence. Detective Maziowski was also present at the execution of the search warrant of the van. This was January 9th, 2 days later. He observed several possible bloodstains on the driver's side of the van, consistently on the driver's side as you're going from front to back of the van. Saw no signs on the van, and you'll have the pictures of the van as well, that the van was ever stuck in the yard or that the van had become stuck. And when he looked at the tire ruts, the tire tracks, also didn't see any evidence of that. He did take a picture and saw the purse in the van that had Linda Stermer's wallet in it, her identification. He determined it to be her purse, and he found $202 in cash. Scott Leroy was the expert witness in the fire investigation. He was called in to determine the cause and the origin of fire at the Stermer residence. He collected these sweatpants that you see at Todd's ankles, as well as the socks and the underwear. He took photographs of some photographs of the Stermer residence that night, more later. And there was no examination of the house because it was still smoldering. It was the night of the fire. So he didn't go into the house due to safety concerns on January 7th. As he's removing the sweatpants, he's smelling accelerants. He went on January 8th to the Stermer residence, and that's when he took several photographs of the Stermer residence. I believe he went around the house, and you have those photos. He examined each room of the house to determine the area of origin for the fire. At the same time, he's also collected any available evidence that's relevant to determining cause or evidence of the crime as he's going around the home. And you can see the gas can that was found the next day. It was also shown in pictures the night before. With all the data that Sergeant Leroy has, he uses it to determine the area of origin. Data of what he's found, data of what he sees, the pictures, the data of the statements made by Ms. Stermer. He uses a systematic approach to examine for evidence and determine the area of origin. He explained to you what he did, what his system was. He talked to you about burn patterns and mass loss, and about how that was used in the determination. And what he determined that the area of origin was the living room. And later, this was confirmed with the additional statements of Ms. Stermer. This is where he marked the area of origin. He talked about mass loss. He talked about the roof that you still have in place. He talked about the walls still in place. And then he matched them with Ms. Stermer and what she saw. This is where Ms. Stermer saw the fire. You've got the recliner here, and where she described seeing Todd Stermer when she came up the stairs. Matches his origin. He told you how he examined several different possibilities. Any causes that he felt were relevant, he used his common sense, formed his hypotheses. At that Stermer residence, he considered the furnace. He ruled it out based on the mass loss, based on the burn patterns that did not support the fire starting in the furnace area in the basement. Also, that furnace is not in the area of origin. It's not in that area. Ms. Stermer didn't describe it in the basement, said she was in the basement, said she came up, and it was in the living room. Considered a possible electric fire in the area of origin. He said there was no evidence that supported an electrical fire. Electrical fires typically start in the walls. The wall studs would have been completely burned away. And also, electrical fires take time to burn, time to develop. He also considered the fireplace as a cause of the fire. He looked at the burn pattern evidence, and it didn't support a chimney or a fireplace fire. He talked about how those timbers right above the fireplace and the header of raw wood above the fireplace. Those timbers around the fireplace would have completely burned if the fireplace or the chimney were the cause. When questioned and talked about the chimney chase and about how the materials would fall on top of the box, he talked about how all of that would burn. And he talked about how fire consumes everything in that little area of origin that it's working on. And then as it exhausts its fuel, it burns out and up. It would have burned everything around it before it moved. He also stated that there would have been a lot of smoke expected in a chimney fire, and that would have been probably noticed by able-bodied adults. Other possible causes were also considered and eliminated. He looked at the fuel oil lamps. They were small. They would have been a very small fire. They weren't consistent with gasoline or a description of the fire from Linda. And per Linda, the fire was not in the dining room or the kitchen, which is where those oil lamps were. He also considered the log rolling out. Talked about how there'd be a slow, smoldering fire, would not have spread quickly, and would have probably been noticed by Todd. He looked at if this was an intentionally set fire. He considered the fact that there's gasoline present in the area of origin with no explanation of why gasoline would be present there. Todd is found with gas on his sweatpants, socks, and underwear. He's on fire in the living room. Why is there gasoline there? It's a sudden fire, described as Linda. She talks about how he was yelling at her and then it immediately turned to screams. Not the description of a small, smoldering fire. She talks about the fire in between, extending from one side of the living room to the other. She talks about how it goes from the bedroom to the recliner, almost as if it's a trail of fire between the two. All of these, ladies and gentlemen, are consistent with an intentionally set fire. Common sense. Now let's look at what Cynthia Deloach said. Cynthia Deloach remembers January 7 of 2007 because it's a small town. She worked that day. She thought her mom's house might be on fire. They drove out there. It was a big deal in their small community. She remembers distinctly Ms. Stermer came to the Marathon gas station approximately 9 a.m. that day. She explained on the receipt the time was off by an hour. Her boss had never adjusted for the time change. She stated Linda purchased gasoline with Todd Stermer's credit card at pump 3. You can see she described the account numbers match on the receipts, which would be here and here. This is the outdoor pump and indoor pumps. And you can see then the name Todd Stermer on pump 3. She specifically remembers the fuel hose going into the back hatch of Linda's Blazer. And I think she actually described it. She said, you know, when you have the glass half and you turn the latch and you lift it up. And she specifically remembers the hose going into the back, underneath that glass hatch. Like if she was filling up a gas can. She did say, I stopped watching after that. After I saw that, I just figured she was filling up a gas can, went about her business. Didn't see then what happened. Didn't see if maybe then she did put it in her gas can or in her car. She didn't know. But she does remember clearly the hose going into the back of the vehicle. You heard from Brad Stermer, Todd's brother. He helped Todd build on several pieces of the residence. He described Todd as a physically fit and a very capable person, very capable man. Todd loved his house. In the driveway of the house, he said it was a path when they were using it, in the beginning of it, when they started it, they used it as a path for construction. But after that, Todd graded it into a yard. So after construction was done, they stopped using it, and that's when he graded it and did the final grade. Todd and Linda, he also testified, were in poor financial condition at the time, and he stated that the horses were a financial strain on the marriage. Linda told him, I'm sorry, I can't read the small print, that on January 9th, Linda told him on January 9th, 2007, Linda described to him that she was downstairs doing laundry and heard Todd yell, Linda. She ran upstairs, she did not see Todd, and she ran out of the house. When he found inconsistencies and questioned her further, that's when she said, he said, well, what about the smoke detectors? Didn't they go off? He knew that he had helped do all the hard wiring for those smoke detectors. And that's when she said, oh, we were having issues with them. Todd disconnected them. And then she didn't want to talk anymore. You heard from Mr. Chris Williams. You heard that he started an extramarital affair with Linda before the fire. About 6 months before the fire, they met at work. He talked about how she pursued him. Showed up at a parking lot one time when he was there shopping. He said he had sex with Linda about twice a week for 6 to 8 months, right in that time frame. Most encounters occurred at his house in Kalamazoo. He talked about how once they did go to see some museums or something in Grand Rapids, and they did some joyriding together, riding around in the car, but mostly it was just meeting up at his house. He said they did try to keep it quiet at work, and he knew she was married. That's why they tried to keep it quiet. He said that he saw a different side of Linda that Friday before the fire when Todd had sold a truck to purchase a van. That's when he saw a different side of her. He also testified from a question that Linda took him to the fire scene months and months later after all the debris had been removed. We don't know why, but he testified she took him there. You heard from Kathy Ilg. Met Linda in 2006. After the fire, she was at the Stermer residence. She noted several school pictures of the boys stacked in frames out in the shed. Linda also told her she needed to look for a cup in the dishwasher, and she wanted to look for some rings in the house. Ms. Ilg got into Linda's vehicle later, and she noted a lot of jewelry in the center console area of the vehicle. You also heard from Kate Fox. They both had kids in Lawrence schools. They started work together at ChemLink. They became best friends. They actually carpooled to work together almost every day. Linda, in those car rides, began to confide to her with problems in her marriage. She started claiming abuse. Kate testified she never saw any signs of abuse. She did tell Kate about her affair with Chris Williams and that she wanted to be with Mr. Williams. The defendant wanted to be with Mr. Williams. She said he was the best lover she had ever had. And Linda told her about wanting a divorce from Todd. Kate drove Linda to Chris Williams' house on several occasions and actually told the police where he lived. Gave them the information of how to contact him. She testified that she knew Linda had 2 phones. One was kept at her house so Todd could not find it. Sometimes it was kept under the dash of the Blazer. She also talked a lot about how the defendant would talk to Chris Williams on the car rides home. She told Kate she thought of several ways to get rid of her husband. She told Kate that she considered shooting him, and she told Kate that she considered running him over with a car. She also testified that she called the police on Thanksgiving, just 6-8 weeks before the fire, because Linda had a gun and said, "Give me one good reason why I should not shoot Todd." She called the police because she feared for Todd. She said Todd was suspicious of Linda 2 to 3 weeks before the fire because he discovered a secret post office box. She asked Kate to go and clean it out. Clean out that post office box, get everything out of it. She also told Kate that Kate said Linda told her that she ran over Todd. She said, one story, it was because it was smoky and she couldn't see Todd and she accidentally hit him. And then she said the second version is that Todd ran out in front of him and then she struck him. She also said Linda called her a few days after the fire requesting a flashlight to locate a cup in the dishwasher of the burned home that contained tranquilizers that she was planning to give to Todd. This is when she decided to have Kathy Ilg reach out to the police, and she wanted it to appear that the police were coming to her, not that she was going to them. She didn't want to walk into the police station. She didn't want to make a call. She didn't want any report saying Kate Fox called the police. She wanted it to look like the police came to her. You then heard the testimony of Dardita Gordon. Dardita is the unavailable witness. She has since passed away, since her sworn testimony. Her testimony stated that she was housed in a jail cell with Linda and that she befriended her. And Linda stated Todd was on medication. She testified to that. And she stated Linda told her she hit Todd with an object during an argument and started the fire. She didn't say what the object was. Even when pressed, she didn't say what the object was. She said it was just an object. And she stated that she started the fire with gasoline. You heard from Corey Pierce, the nephew raised as a son by Todd and Linda. You heard what happened the night before the fire. He was sleeping downstairs. You heard parents arguing about Linda cheating. He said Linda did not come downstairs that night. He did not hear his father working on the furnace, and his bedroom shared a wall with the furnace room. He says the day of the fire, he woke up to an argument between Todd and Linda about cheating. Linda came down and sat on the bed and said the boys needed to leave so that her and Todd could split up property for a divorce. Told him to take his brothers to Kalamazoo. And she told him she wanted Todd to think the boys were still home so that they would argue less. The day of the fire, Corey testified that he went upstairs, he saw Todd sitting in the living room, saw his arm, but he didn't see his face. He testified that Linda blocked one of his brothers from going to see Todd. He testified it was always common practice to give a hug and a kiss and say, "I love you," before leaving the house anytime. He specifically remembered seeing Linda's purse on the kitchen counter when he walked straight up the stairs. He said Linda told him that there were some statements about what had occurred in the fire, and those conversations usually happened in the vehicle with his brothers after the fire. He said one version, there was too much smoke when she tried to get up the stairs, and that she ran out the basement. Another version was that she ran upstairs and saw Todd on fire and ran to get help. When the brothers would question her differing events, like we talked about in voir dire, confronting with conflicting statements, that's when she would yell and become physically violent. He stated Linda coached him and his brothers on what to say prior to any interview or testimony, and said if they didn't listen, they didn't listen to her instructions, that they wouldn't receive any insurance payout to replace their things that they had lost in the fire. You heard from Trenton, the youngest, who's 12 at the time of the fire. He remembers an argument the night before. He stated Linda did not come down in the basement the night before the fire to watch TV or to cuddle with him. He said Linda did not sleep downstairs, and he did not hear Todd in the furnace room. The morning of the fire, he stated Corey woke him up, they got ready, they went up the stairs. He stated Linda blocked him from seeing Todd. It seemed like Todd was sleeping, but she shooed them out of the house. They left the residence in the black Blazer. He said that when Linda talked to them about what happened, there were differing stories. One version was she couldn't get upstairs and that she exited out the basement. One version was that if she could get upstairs and then she exited out the front door. He said Linda would attack him if he confronted her with her changing stories. He stated Linda gave him a bloody nose on one occasion and would instruct his brother Trevor, the older brother, to silence him when he started questioning and pushing. Linda told him to say, "I don't remember," to certain questions during the insurance investigation. Lastly, you heard from Trevor. He said that the Stermer home was about 95% complete. They were missing some floor coverings, but he said about 95%. He said there were working smoke detectors, and he actually talked to you about how they would beep and he'd have to replace the batteries. He said Todd was meticulous about safety. He said the night before the fire there was a very heated argument. It was the worst one he'd ever heard. He was asked to leave his brand new bedroom in that loft and go stay downstairs with his brothers because of the severity of the argument. Also had an open loft area, so probably was for the noise as well. She told him he talked about why they were arguing. He said it started with finances related to Linda's horses, and then it transitioned into Linda's infidelities. He also said Linda did not stay in the basement on the couch or cuddle with any of them that night. And Todd did not come downstairs that night. He said on January 7th of 2007, he woke up at 8 a.m. He tried to go upstairs, but Linda stopped him. Remember, he was the first one to wake up. He woke up early, and he wanted to get some breakfast. And she stopped him twice from going upstairs. Said another argument broke out that morning. And I think he actually said Linda brought him down a Pop-Tart at one time. Linda asked the boys to leave the house to go to Kalamazoo to a mall and movie. He didn't want to go. He wanted to wake up his dad and make an argument of why he wanted to stay. Tried to speak with Todd twice, just hoping maybe he could just stay home. And both times, he was blocked by Linda from going to talk to his father. He said after the fire, Linda's stories changed each time. What door she exited would change. She'd get angry and attack his brothers, or direct him to attack Trenton to stop the questioning of her stories. He said Linda sheltered them from any outside information. He only knew the facts as provided by Linda. He also coached them on what to say when questioned by the insurance or police. He also remembered a duck boat. He remembers Todd having a small plastic duck boat. He said it never had a gasoline engine. It had oars that they would use. And they would take it out in the back pond to go duck hunting on the property. Told a story about how Todd let him spray paint it camouflage with the green and black paint. He also said Linda's horses were an obsession. So let's break it down by the elements. Remember, you, as the jurors, have the opportunity to look at all the evidence. All the evidence surrounding this fire and making your determination on whether this was an arson fire set by Linda Stermer. No one witness is the entire case. You get to judge all of the evidence, and it's your decision. Start out with the second element of arson. We know at the time of the building, they were living there. It was a dwelling. So I've checked the box. Let's look at the evidence that would support the other two. What's the evidence that supports arson? The defendant bought gasoline. Actually, I'm going to stop there for a moment. I'm going to read to you the definition of circumstantial evidence, not in entirety. You'll have the entirety when you go back. Circumstantial evidence is evidence that normally or reasonably leads to other facts. Common sense. The defendant buys gasoline the morning of the fire. She's observed by Cynthia Deloach to have the hose in the rear of her hatch. The only reason would be to be filling a gas can. She's certainly not pumping it into the interior of the car. There's a small 1-gallon gas can found in front of the Stermer residence at the fire. There's no explicable reason for this can to be in this location. You saw a picture of all the gas cans neatly stacked in the shed. All of them, except for this 1 gallon. You heard the testimony about the huge tractor and how they wouldn't use a 1 gallon to fill up the tractor in the backyard. Gasoline is found on Todd's sweatpants, his underwear, and his socks. What leads to a logical progression? Then you can look at Linda's misdirection as evidence of an arson. In any detailed statement, she attempts to redirect towards the fuel oil furnace. She consistently mentions Todd bleeding the furnace the night before the fire. There's no evidence that supports this. As if she's redirecting you to think that that's why he would have fuel oil, which we know now is inconsistent. Fuel oil tests differently from gasoline. Fuel oil is chemically distinct from gasoline, and that's what you heard from the chemist. She tried to claim Todd accidentally started it with a dropped roach. There's no THC found in his system on that autopsy. It's not in his system, it's not in his blood, it's not in his urine. She describes what we call a fire trail in the living room. She stated that it wasn't the fireplace. She detailed and described the path going from the recliner to the bedroom where Todd was. She described an excellent trail across her living room. It's like, what else? The suddenness of the fire. Todd went from yelling at her to immediately screaming in pain. You also heard witnesses talking about how within minutes of getting there, it just started to it was consumed. They were watching how it just started breaking through. I think Musali's, Matheny's, Thompson's, everybody was talking about how quickly it just was being consumed. This implies that it happened quickly from her statements. 1 minute it's not there, the next minute he's yelling in pain. Now that also we can look at the fact that she ran Todd over as evidence of an arson. He's the only witness to the crime other than her. And after Linda, sorry, your type is very small. After Linda realized he escapes, his survival would have left Todd as a possible witness. And she needed to silence that witness. You can also look at supporting arson, that she's laying on Todd, because that supports her intent to silence him. She laid on a man whose skin is sloughing off. They tried to carry him away and they couldn't because his skin was coming off, and they had to put him in the boat to move him. She laid on a badly burned man who she described as pink melt and talked about how he was struggling to breathe. Why would you lay on a person with that severe injury and who's struggling to breathe? She had to forcibly be removed from him as they're trying to render aid 2 times. This can all be considered as part of the arson. You can also consider that she let the dogs out moments before the fire erupted. She didn't want her dogs to be killed in the fire. You can also consider that there were framed pictures of her children that were moved to a shed on the property. Precious keepsakes were spared, things that can't be replaced. The boys, pictures, the dogs. She didn't have to worry about the horses, they were outside. You as jurors can take the totality of all the evidence presented, all of the evidence presented, supporting that Linda intentionally set that fire. The element, the defendant burned the building. We believe we've given you the evidence. We believe that we've given you everything you need to make that common sense approach. What makes sense and leads to the conclusion? The conclusion is that the defendant burned that building, it was a dwelling, and that she intended to burn it. So let's go to count one. Let's go to evidence of murder. Actually, and it applies to count one and count two. What then gives the support for the details of the murder? The details of the day of the fire are very inconsistent. You can look at her statements. She tells multiple stories about how she exited the residence. She tells multiple stories about what she saw. She tells multiple stories about why there's marital discourse, but denies that she's having an affair. She only gives the details she thinks won't incriminate her. You can also look at the reason for driving the van into the yard, which makes no common sense. She drives to an area worse off than that inclined driveway. The inclined driveway that fire trucks are coming down, emergency vehicles are coming down. You saw pictures of it the next day. She drives to an area worse off than the driveway. She drives to an area that's more difficult traction, down a hill. She claims to be trying to get help, yet she drives into the backyard when Mike and Connie are driving down to her. She's in the driveway when they see her. Tracks in the yard show the van going from where Todd was laying in his pool of blood to the backyard. Claims to not know she hit Todd, yet the blood is all on the driver's side. There's a reason we talked about that in voir dire. You guys gave descriptions of what you heard when you hit a squirrel, a raccoon. This is all on the driver's side, and there's 7 points of impact with Todd's blood. She claims she didn't know she hit Todd, yet blood's all over that driver's side. And once she claimed, maybe in an attempt to try to cover her tracks, to one person, that she got out and leaned Todd against the bumper of the van, and that's why blood was present. Which is interesting, because he would have had to have been bloody before she hit him and then leaned him up against the bumper in order for that blood to get there. What else can we look at for evidence that it was a murder? You can look at the evidence that Dardita Gordon gave you in her testimony. Linda admitted to striking him with an object during an altercation. She admitted to starting the fire with gasoline. She knew Todd was on a medication. That's an odd fact for somebody at the jail to know without directly being told by the defendant. Todd suffered multiple lacerations that can easily be explained as a result of being struck by a blunt object. There's one completely in the back of the head. There's one on the top of the head. There's two on the sides. One could easily be explained by a blunt object. Perhaps even the frying pan that you see in the rubble that was not above, there was no kitchen above, and it was found in the laundry room. She admitted to wanting Todd gone. You can consider that evidence. She concocted ways to kill Todd. She thought about running him over and said that to Kate Fox. She thought about shooting him with a gun. That's why Kate called the police. She'd become violent with the boys. You can consider that. When confronted with inconsistencies, she became physically violent with the boys when they pressed on her inconsistencies. She coached the boys on what to say. Why would she have to coach them on what to say? She told them what to say at interviews, told them what to say to the police. She'd only do this. She's trying to hide the truth. Why didn't she just tell him, tell the truth, tell what you know? Why'd she coach them on what they could say? So let's look at evidence of premeditation, because that's count one. You gotta find evidence of premeditation. First thing, purchasing gasoline. You can consider for all these different things. You can consider for the arson. You can also consider it as evidence of premeditation. She gets up in the morning. She buys gasoline the morning of the fire. Cindy sees her putting the hose in the rear of the hatch. Only logical conclusion, she's filling a gas can. A 1 gallon gas can is found at the front yard at the time of the fire. Tells Kate Fox she wants to kill Todd. She's thinking about it. It's premeditation. She's thinking about it. She contemplated differing ways of completing the act. She attempts to frame Todd. You can consider that. She uses Todd's credit card to purchase gas. She claims she didn't have any money, which I read to you, which is why she used the debit card, but yet she has $202 in her wallet in cash. Why is she using Todd's credit card? She wanted to look like Todd was the one that bought the gas? She consistently tried to paint Todd in a terrible light, despite having no evidence to support her accusations. Blame shifting. You can consider that as evidence of premeditation. You can also consider that she sent the boys away from home. She's thinking about it. Why did she send them all away? She told them to call first before coming home. She didn't let them see their dad. She physically blocked them from seeing their dad. Keys were waiting for him in the Blazer. What else? Her purse. Her purse and her money were found in the van. Corey specifically remembers that purse on the counter when he came up the stairs, said he was looking right at it. Linda was preparing to be gone after that fire started. That's the evidence the morning before the fire starts. But you can also consider additional premeditation. She sees Todd escape the burning residence. He's screaming, pulling off his clothes, hollering in the yard. She can't let him survive. He's going to tell what happened. So what does she do? She gets in the van. She makes a nice little arc pattern to the north side, into the backyard, and runs him over. She strikes him on the driver's side, directly in her line of sight. And she tells you multiple times, I saw him in the yard, then I got in the van. She saw him before she got in the van. And what did she do? She drove immediately and drove over him as Mike and Connie are coming up behind. That's the second instance of premeditation. You got the premeditation in the morning about the fire. Now you got the premeditation of trying to run him over when he escapes. But now let's talk about the third time and her attempt to try to silence him when she doesn't kill him after she runs him over. He's breathing. His heart is still beating. He's struggling to breathe. His mouth is moving. And what does she do? She jumps on him, face to face, on his burned body. She places herself on his body, covers his face with her hands, by one witness's description. She has to be forcibly removed by people who are trying to help him and render aid. She knew he was struggling. She knew he was hurting. And she laid on his body. Why? She's thinking about, what if he talks? What if he lives? Judge is going to give you an instruction. We don't need to prove motive, but it's something you can consider. It's not an element, not a box, but it's certainly something you can think about. What could be the motive? Well, you got finances, cash strapped, behind on bills. Todd's lazy, doesn't work enough, doesn't make enough money for her. Divorce isn't going to benefit her. At the time, she has multiple horses. Horses are very expensive. Without money, you can't care for them. Without land, you can't care for them. Divorce would have likely have ended up in a place she wouldn't have had a place to keep her horses. Her obsession. Let's talk about Chris. She has been engaged in a 6-month relationship with a man she wants to be with. Best lover she's ever had. Wants to be with him. It's a long-term affair. Ends up going at least 8 months before she breaks it off with him after the fire. Let's talk about common sense. I told you, don't check your common sense at the front door when you come in this courtroom. Let's talk about why Linda's story makes no sense. She's involved in a terrible argument with a man she claims is abusive. Yet, she goes to the store and she makes him breakfast, builds him a fire because he says, hey, it'd be a good day for a fire. Yet gets him juice when he asks. Yet she putters about the house. Yet she puts Christmas decorations away. She reads an acne pamphlet and takes a nap. Yet sends her children away from the home and her main source of transportation on the day she's supposed to be moving to her sister's. They're getting ready for such a huge fight. They're splitting up all their assets, send the boys away because this is going to be so horrible. And she's making breakfast and putting Christmas ornaments away and taking a nap. Why didn't she just pack and leave? It doesn't make sense. Why did she drive the van in the manner that she did? She claims she drove the van to get help. Yet help is coming down the driveway, the very help she said she's getting ready to go get. She's going to get Mike and Connie to help. They're coming down the driveway. Why? Why is she driving to the north side of the house when help, the very help she wants, is coming down the driveway? She claims to not have ever seen Todd in the side yard. Yet she strikes him on the driver's side, going at what we've heard may be slow speeds. She lines up and hits him on the driver's side. She says it was so smoky she couldn't see him in the yard. Look at the smoke, ladies and gentlemen. There's no smoke in the side yard. Certainly not obstructing your view in the side yard to see. You could see the trees in the background. Common sense says if you got outside, you saw your loved one escape that house on fire. Common sense says, I'd probably better go and try to help this person because by the time I drive down to the neighbors, how many feet away, this guy's going to be burned up. Common sense, okay, let's say you panic and you don't think that way. Common sense would be like, oh my goodness, my husband, the father of my children is on fire. You'd keep your eyes on him to see what's happening. She says, I see him when he comes out. He's on fire. But then she claims, then she didn't know where he went. Doesn't make any sense. Why she drove onto the backyard? She claims it was to get better traction. Testimony established this was not an improved driveway. You saw the pictures. You can have them back in the jury room with you. Traction in this area is way worse. Going down a hill. Think about your grade, your basement. Even if you have an 8-foot ceiling, you're going down 8 feet. Claimed she did this to get to the neighbors, yet the neighbors are already there. So let's talk about what does make sense. What leads from one conclusion to another? The morning of the fire, Ms. Stermer gets up. She's contemplating the fire. She goes, she purchases gasoline, and she removes the things most precious to her from the home. Probably, makes sense, she was arguing about her affair with Chris Williams, with Todd. She strikes Todd with an object sometime during that altercation, just like she told Dardita that she struck him during an altercation. And now you've got a possible laceration from blunt force trauma on the head. Dr. Markey testified that you can knock somebody unconscious without having any brain trauma, that just having that indentation, you could knock somebody unconscious. Also makes sense that she had planned to drug Todd with a cup in the dishwasher, but she changed course. Maybe that argument got out of hand. Maybe she just changed her mind and decided this was an easier way. She douses Todd with that gasoline that she bought that morning. So gets it on his underwear, socks, sweatpants, recliner. And he's not on fire yet. She runs downstairs. We don't know. She's changing clothes. She's letting the dogs out. Did she ever run downstairs? We don't know. If she does, we don't know why. Maybe she's changing clothes. She doesn't expect the fire to erupt as quickly as it did, because she doesn't know it's the vapors that were testified to that can ignite. You have an incapacitated man with gasoline on him. You run downstairs to grab something, do whatever you're doing, those vapors ignite. It would explain why it's sudden. It would explain why it catches her off guard. Who knows? Maybe she planned on going up and knocking a candle over. Maybe she planned on throwing in a match. It just happened too quick. Those vapors ignited. You've got that open source of flame, that fireplace, and it just erupted before she's ready. She flees the house. Here's the top of the stairs, as she describes it and as Corey describes it. She gets to the top of the stairs. There's the counter, right where her purse is, right where Corey described it. She grabs her purse in an attempt to escape. Maybe she thinks she can just get in the van and drive away. He'll burn up. She'll have an alibi. She's not at the house. So she's going to drive away. Problem is, Todd escapes. She sees Todd. He's in the side yard, ripping off his clothes, screaming. At that point, she's thinking, he's alive. He's got to be silenced. What does make sense? She gets in that van. She's trying to flee. She sees Mike and Connie coming down. Now she really panics. She can't leave this burning man in the north side of the yard, hoping he's just going to die, and she could drive away. Now she's been caught. She's been caught by Mike and Connie. What's she going to do? Is she going to take the chance that he's getting that fire out and going to tell Mike and Connie what happened? She panics. She pulls off the driveway into the rear yard. She lines Todd up with the driver's side and she runs him over. And I want you to think about relating that to all the stories she told Willison and Shinsky. Those are so elaborate. Driving, getting out, trying to help. He won't lay down. I get back in the van. I then drive, then I get stuck. Didn't happen. No time. Connie and Mike saw her right in the driveway. There was no time for any of her elaborate story to occur. There's no time. What does make sense? Todd gets out of the house on fire. She runs him over. She runs over to him. Oh my gosh, he's still alive. He's breathing. His mouth is moving. Now what do I do? I'll tell you what she did. She made another attempt to silence him. She jumps on a man who is struggling to breathe, placing her hands over his mouth. In yet her third attempt to make sure he can't talk and tell what happens. Using your common sense, that makes sense. The facts as told by Ms. Stermer make no sense. Then you often look at the cover-up. She tells multiple half-truths. We talked about half-truths in voir dire. We talked about what you do when you have a half-truth. She gives half-truths about the events of the day. She gives multiple versions of the events. She changes details surrounding the cause of the argument. She can't even keep straight what door she goes out of. She becomes physically violent or emotional when she's confronted with inconsistencies. She coaches her sons on what to say. More questions lead to differing stories. This is because, ladies and gentlemen, she can't tell the truth of what happened on January 7th of 2007. Because the truth makes her guilty of premeditating that murder, of trying to kill him in an arson, and ultimately his death. She wanted to make sure Todd was dead that day, and she wanted to make sure she did everything possible to make sure he did not survive. He didn't survive the house, he didn't survive the van, and he didn't survive even laying on that ground. She did whatever she could. Ladies and gentlemen, common sense. These boxes are checked. Linda Stermer caused the death of Todd Stermer. She intended to kill Todd Stermer. Her intent to kill was premeditated. You have all kinds of evidence of that. And that killing was deliberate, meaning she thought about it, she weighed the pros and cons, and she made multiple actions, confirming that that was her intent. She had time to think about it and change her mind. She didn't. She caused the death of Todd Stermer. She had one of those three states of mind. She either intended to kill him, intended to do great bodily harm, this is count 2, or she knowingly created a very high risk of death, knowing that that death would likely be the result of her actions, and that when she did that act, when she caused the death of Todd Stermer, she was committing or attempting to commit arson. Those are your elements. Ladies and gentlemen, common sense tells you those boxes are checked. You have all of the evidence. You have everything for that logical conclusion. I'm asking you, ladies and gentlemen, to go back into that jury room, go through that evidence in more detail that I've given you. I've given you a snippet over the 3 weeks that you've been here. I tried to sum it up for you. You have more. You can review anything you want back in that jury room. Look at that evidence, piece it to those boxes, and I'm asking you to find Linda Stermer guilty of both count 1, premeditated murder, and count 2, felony murder during the commission of the arson. I appreciate all your time and attention. Thank you.
Thank you, Mr. Mueller.
Thank you, Your Honor. Give me just a second for a little housekeeping. Yes, thank you.
Ms. Seiderby? I think he wants to approach. Mueller's closing argument, so we'll make it the usual, about 15 minutes, directly to the jury room. Remember your rules. Council, any matters to address in our break?
No, Your Honor.
No.
Oh, okay.
What time?
2:30-ish. I told him about 15 minutes, 2:35.
Yes.
Okay, counsel, we're back on the record. Any matters to address before we bring the jury back in?
None, Your Honor.
None, Your Honor.
Thank you. We'll bring in the jury. Welcome back. Mr. Mueller, closing argument?
Thank you, Your Honor. Good afternoon, ladies and gentlemen. This is our last time to speak with you. The prosecution has the burden of proof. We'll go into that, but that's why they get, in a case like this, the last say. This is the only time, excuse me, that I get to speak to you. I want to thank you on behalf of Linda Stermer and our team for the attention you paid throughout this case. Everybody took notes and asked question after question after question. So I know you're paying attention, so thank you. I want to tell you a little bit about your job. When you go back to the jury room, you actually have 3 jobs back there. One, obviously, is to decide the facts of the case and how they apply to the law. The second job you have is to make sure that everybody on this jury follows the law. And when I say follow the law, when you were sworn in and we selected the jury, a lot of questions about the presumption of innocence, the burden of proof. As Linda Stermer sits here today, she is innocent. As Linda Stermer, when you go back into the room, when you walk through those doors, she is innocent. That is a solemn oath you took to hold that throughout this case. The third job you have, when you go back there, is to explain your position to the 11 other people on the jury, how you saw the evidence, what you thought about, how you considered it, and to also listen to them fairly and make sure that everybody gets their word. When you follow the law, what I'm saying is you have a right as a juror to make sure that when you go home after this case, everybody followed the law. Nobody bullied anybody else into trying to cave their opinion without following the law about presumption of innocence and the high burden of proof beyond a reasonable doubt. You heard Ms. Zuderveen speak for an hour and a half, and I timed it. She spent 5 minutes on the fire and the cause of the fire. So let me tell you what this case is not about. This case is not about a van impact. You heard Dr. Markey on a witness stand. Dr. Markey and Ms. Zuderveen said what she thought Dr. Markey told you. The one thing that Judge Brickley will tell you is what we say here is not evidence. What you heard from the witness stand, that's evidence. That's what you consider. And I'm sure Ms. Zuderveen didn't intend to misrepresent anything, but she didn't have a transcript of his testimony like I do, like we purchased. So I want to tell you what Dr. Markey said in terms of the cause of death. On page 19, Dr. Markey said to a question, my question. Well, let me just kind of summarize and make sure we're clear before I leave you. The van impact had no connection with the death. The death was caused by thermal burn injuries. Fair? Said yes. I believe his death was caused by the thermal injury. Dr. Markey's opinion is the official medical opinion in this case. It's undisputed. And the government, the state, with all its resources, couldn't find another doctor in the state or in the country to say that the van impact had anything to do with Todd Stermer's death. It was solely caused by the fire. And Linda Stermer has not been charged in this case with anything having to do with a vehicle impact to Todd Stermer, not even a misdemeanor. So what does that tell us? One, the van didn't cause the death, and the van certainly didn't start the fire. Why did they spend so much time on the van? Well, I'll tell you. Because they wanted to distract you from the fact that they have no evidence of how the fire started. This case, ladies and gentlemen, the charges are first-degree premeditated murder. Ms. Udovine showed you the jury instruction and went through a whole bullet PowerPoint. Boiled down to, Ms. Stermer intended to kill her husband, thought about it for some time, and then carried it out. But the carried it out part is she's charged with felony murder. The felony is arson. So if there's no arson, there is no crime. If there is no crime, there is no premeditation. And so when you consider what you need to do is look at two things. Was the fire intentionally set? And if it was, did Linda Stermer set the fire? Those are the simple issues in this case. The burden of proof for the state is extremely high. Let's talk about that. Burden of proof is beyond a reasonable doubt. Reasonable doubt, ladies and gentlemen, simple terms, is doubt based on reason and common sense. If you have any doubt, as you look at all the evidence today that I'm going to show you and summarize the evidence, if you have any doubt that doesn't require you to abandon reason, then that's a reasonable doubt. And what is a doubt? Well, remember I explained it with Mr. Leroy. To lack confidence in, to not trust. That's doubt. Here's the burden of proof, ladies and gentlemen. In a criminal case, the burden of proof beyond a reasonable doubt is the highest burden we have in any kind of case. And the reason is because when the government is going to take your freedom, our founding fathers made sure that they couldn't just say, we don't like you, we think you're guilty, and we're going to put you in prison. So what do we do here? Let's look at this. Is there a slight amount of guilt? Not good enough. Is she possibly guilty? Did she possibly set the fire? Somebody says that, you say not good enough. I've done a lot of civil cases where people sue for money, car accidents, product liability. In a civil case, the burden of proof is a preponderance of the evidence. Is it more likely than not that we believe Wolf's side or the other side? Kind of people like to say 51% versus 49. If it's 51%, more likely than not, then plaintiff prevails. That's not this case. Is it probable? Somebody says, I'm pretty sure, I think she probably did it. Not good enough. So when we talk about, as you go back into the jury room, what your lens is, these are the burdens, the things you need to consider. Very probable. I think almost for sure she did it. Not good enough. And here's the other thing. In a civil case, the highest burden we have in a civil case is called clear and convincing evidence. That's not good enough. What does that mean? So when you go and address each other in the jury room, Clear and convincing evidence under the law is to be clear and convincing. The evidence must be strong enough to cause you to have a clear and firm belief that the proposition is true. Not good enough. Somebody tells you in the jury room, I really feel she set the fire intentionally. Not good enough. If you have any doubt as you look at the evidence that is supported by reason and common sense, no matter how small, that's reasonable doubt. And your job as a jury is to return a not guilty verdict unless the government, unless the state meets that high burden, exceeds beyond a reasonable doubt. Your job as you go in there, unless they do that, is to return a not guilty verdict. The other presumption is the presumption of innocence. Your Honor will read you the law, and the law says this. We start out with the presumption that where there's a fire, the law assumes that it had a natural or accidental cause. The prosecutor must overcome this assumption and prove beyond a reasonable doubt that the fire was intentionally set. You start with the presumption that's an accident. So that's the lens you need to look at as you go through this case. You know, before we started, I forgot, one of the jurors asked, why would this case take 3 weeks? Should it maybe take 2 weeks? Because after all, it is only an arson case. Todd Stermer died of a fire. So you just have to decide whether the fire was intentional, and if it was, 2 issues, did Linda Stermer intentionally set the fire? Instead, what you heard, and I counted the witnesses, 20 witnesses over 1 week, to talk about the van, to talk about infidelity, to talk about other issues. And why? Because the state wanted to distract you from your job, which is simply to decide, was this an intentionally set fire? And it's interesting. In opening statement, and I had that, everybody took good notes, I'm sure, so you'll be able to go back to opening statement. The prosecutor never said what caused the fire. And here, after 3 weeks, Ms. Zudovine spoke for an hour and a half and spoke for 5 minutes on the fire. And the best she could do is say that Scott Leroy said the fire was consistent with being intentional. You don't get a conviction based on it would be consistent with being intentional. Experts, as we'll talk about, are held to high standards. There's no guesswork in experts. You don't get to speculate. We'll talk about speculative opinions that Mr. Leroy had and possibilities. You heard from every legitimate expert in this case, starting with the MSP chemist, Troy Ernst. We don't engage in speculation. Speculation masqueraded as an expert opinion is misleading. So that's why we don't do that. Your decision must be based on the evidence. The evidence that is clear, credible, and compelling factual evidence, not speculation and guesswork. So when you deliberate, you start with the assumption and the question, assuming Linda Stermer did not set this fire, did the prosecution meet its burden of proof beyond a reasonable doubt for every fact it needs to prove to meet those elements, those boxes that she talked about? And if they can't rule out reasonable doubt, if they can't rule out alternate causes, if they can't rule out alternate theories, if you can't rule it out, that's reasonable doubt. And we'll talk about that as we go through this. It's got to be based on the evidence. You know, one thing we heard when you were being selected, and you'll remember this, Ms. Zuderveen, when she was asking you questions, asked you this. It might take, to present all the evidence, we might be here for 2 months. So will you give us a pass? Will you not hold it against us if we don't give you all the evidence? You're darn right you have to hold it against them. They have the burden of proof of bringing all the evidence they have to establish guilt beyond a reasonable doubt. They don't get a pass, and you can't give them a pass because they didn't bring you evidence. We'll talk specifically, but I do remember one thing I wanted to bring to mind. There was that video, remember Deputy Gruss did the in-car video, and it showed 10 pictures over 9 seconds. One of the critical issues in this case, as you remember, is how fast was the fire, the speed of the fire, the direction of the fire. 10 stills over 9 seconds. I asked Deputy Gross, what happened to your video? I don't know. Don't you think it might be better, since we're talking about speed of fire and direction, if we had the video? Would that help? Yeah, that would help. But they didn't have it. So they can't help you with a critical decision in terms of the speed and propagation of the fire. So when you think about evidence that they say they don't want to show, that they don't have to show, can you give us a pass? Don't hold it against us. You hold it against them. So why is Linda here? Why is Linda Stermer, after 18 years sitting in the defense seat? Well, how about there was a house fire, and as soon as the police got there, there was a man who died, and then there was blood on a bumper. So they rushed to judgment and automatically assumed someone's dead, someone's alive, blood on the bumper, has to be a crime. And you remember Sergeant Leroy, when he arrived on the scene, spent a lot of time telling you about the pictures he took about the bumper, because he suspected it was a crime. He took more pictures that night of the vehicle than he took of the house. He is the state's origin and cause expert. This became a rush to judgment with no evidence. In fact, what it really was, as you will see, this was a prosecution looking for a crime because they worked backwards. Why do you think Ms. Zuderveen spent the majority of her time this afternoon and the majority of the case talking about infidelity, talking about having romance and best sex ever, and wanted to run away? Nobody said she wanted to run away with somebody. Chris Williams didn't say that. You can look at your notes. No, they wanted to show you the why, the motive. Remember, she said, we don't have to show you motive, but they spent the whole case and the whole afternoon talking about motive. Because they wanted to show you the why so you wouldn't focus on, how about the where? How about the area of origin? And more importantly, how about the how? Because they can't tell you how the fire started. Sergeant Leroy, when you go through your notes, and I'll summarize it, you will not find anything where he said he could identify the cause of the fire, how the fire started. And if you can't identify the how, and even the where, then you certainly can't identify the who. This was a prosecution looking for a crime, working backwards. And all because they found blood on the bumper. Ms. Stermer, from pretty much the first night, within a couple hours, had a target on her back, a bullseye on her back. She's grieving the loss of her husband, and they make her take her clothes off to give it to them for evidence within 2 hours. Her husband's still there. Remember, you saw the pictures from Sergeant Leroy. He's there at 7 o'clock at night taking pictures of the body. She has to take her clothes off and switch clothes. She had a target on her back, a bullseye on her back, only because there was blood on the bumper, and as Sergeant Leroy said, time of day and 2 able-bodied people, and only one of them survived. And we'll talk about that is no kind of scientific evidence. We're going to talk about the scientific method in a bit. But I wanted to tell you about one thing. As you look and listen to Ms. Zuderveen, one of the things that she was talking about motive was the idea of they were in debt and she had a financial motive and she wanted to get money so they could clear the debts and whatever. Remember what Attorney Willison said, who interrogated Linda Stermer for 2 days? After his investigation, he's a 30-year lawyer, doing nothing but exams under oath, trying to detect fraud. What did he say? And your notes will say this. There was no financial motive. I looked. There was no financial motive. There was no romantic motive. So when you think about what's been said here, it's all about credibility. We lawyers, we hope we have credibility. We hope what I tell you is backed up by your notes and the evidence. But what Ms. Zuderveen told you about a financial motive was completely opposite from what the witness said. It certainly wasn't about romance and sex. Now let's talk a little bit about what Sergeant Leroy did, because we're going to talk about the fire investigation. Remember, we talked about the scientific method. You probably learned more about the scientific method if you're not into science than you ever wanted to. I used to be an engineer, and sometimes it makes my eyes glass. You have to collect the data. Most important step. This is always for these fire guys, figure out the ordinate cause. So it really starts with step one here. Collect the data, all the available data that you can that might be relevant to the task. Even Sergeant Leroy said that. All the available data. Remember, witness statements, building records, we'll talk about those, physical inspection, excavation. Collecting data includes excavation of the property. That's where the gold is. That's where the evidence is. That's where you find the burn patterns and the objects that show you where the fire started and what could have caused the fire. Sergeant Leroy, under oath, and he admitted this, remember this? If you don't collect the data, you can't analyze it. You have nothing to analyze, which means you can't develop a hypothesis, which means you can't test anything because you don't have that, and you can't select a final hypothesis. If you don't do every single step, what did he tell you? You have an unreliable methodology. And if you have an unreliable methodology, what did he tell you? You have an unreliable opinion. It can't be relied upon. It can't be trusted. The very definition of doubt. Garbage in equals garbage out. So we're going to talk about all the various things he did and whether it complied with the scientific method like he said he did, or this guidebook which every single fire investigator trains to, tests to, and teaches to, NFPA 921. There were some questions about, this is the 2024 version. It's been going on every 3 years since 1992. But the main thrust is you have to comply with the scientific method. The scientific method has been around in the sciences for decades. And so the fact that this was 2007, we're in trial in 2025. The 2024 version is what is in effect, what you have to comply with. And you might say, well, why are you holding the guy to 2024 when it happened in 2007? Because you have to be open to change your opinion based on new developments. And in this case, there are no new developments. It's the scientific method. Collect the data. Follow the steps. That's fundamental, was fundamental in 2007, was fundamental in 1992, and has been fundamental for decades before that, the scientific method. So let's look at what Sergeant Leroy did. Sergeant Leroy got to the scene on the 8th, and then under oath, he told you he went through the building and he cleared with his friend Greg Stormzan, who you heard from yesterday, an area 20 feet by 20 feet by 2 feet, 800 cubic feet of debris. And what does that debris look like? This is Sergeant Leroy's picture of his area of origin. Oops. Oh, should be coming. There we go. What did Mr. Leroy's area of origin look like when he was there? You see this? Right here, that's the first floor fireplace that we've been talking about. Here is the chimney chase that we were talking about. We'll talk about more about that. But here is the 2 feet of debris in this 20 by 20 living room that extends from the fireplace all the way to the bay windows. And what was his testimony under oath to you? Greg Storms and I cleared the entire living room and deposited it outside. And he said my pile was 4 feet by 8 feet by 7 feet high, as tall as Shaq. When you do the math, that's nowhere near an 20 by 20 by 2 cubic feet. That's about 28% of it, if I had a calculator. And what did it look like when the next person came? The next person who came was Mr. McHugh. You remember that? And he took a picture of the back. He was there on the 10th. 2 days after Sergeant Leroy, on the 10th, and he testified, I think it was yesterday, maybe the day before, and all he saw was this. And then Mr. Shinsky came, and Mr. Shinsky came a couple days later on the 11th, and his picture was better. But I ask you, where is this 4 foot by 8 foot by 7 foot high pile that Mr. Leroy said he excavated? Somebody steal it? He actually almost said, I don't know. Or maybe. Here's the thing. You remember Mr. Shinsky? He said, I had to come back on the 15th with an excavator because it was too dangerous. So if it's too dangerous for a veteran like Mr. Shinsky, who, by the way, trained Mr. Leroy, then you know Mr. Leroy wasn't doing any excavation of the whole living room floor, and there was no clear 20 foot by 20 foot area. Shinsky's picture, after they came back with an excavator, you remember, here's the fireplace area, and there's the living room, goes out to what would have been the bay windows. Look at all that rubble, look at all that debris. I could and by the way, Mr. Shinsky testified that he did the excavation. How do I know what he exactly said? Because I have his transcript, and we have his words. And his words were, in reference to the structural damage, you would then have to contract with someone else to come out and do the excavation of the house. Correct? No, I conducted that. You did the excavation yourself? Yes. Physically, hand by hand? Physically, hand by hand. And hired an excavator so we could remove the areas of the house that were hanging over the burns out section of the rear of the home so that it was safe to get in and actually do that. And then he continued, how many days did it take you to perform the excavation of the property? He said, I believe I was there for 2 days. You remember when Mr. Leroy first told you that he looked for his pictures of the excavation and he couldn't find them. And then this half-truth, sometimes you just got to keep asking questions, and then you get to the truth. And then he says, I didn't take any, and I didn't make any reports. His testimony is directly contrasted by Mr. Shinsky's. And what was his excuse? It was a long day. I was tired, and I forgot. You remember I asked him, would you take that answer from some of your training? What was his answer? Yes. Well, it depends on the fire. This is a death case. It doesn't get more serious. Like Mr. Stormzan said, you have to bring your A game. Leroy, I can say it in lawyer terms, his story was demonstrably false. But if we want to just be real, he lied to you. And if he lied to you, you can't trust his opinions. Because if you can't trust the messenger, you can't trust the message. So when you go back and you analyze Mr. Leroy's work in this case, think about that. He lied about the very thing he needed to do, step one, collecting the data, so he could get to the conclusions, so he could develop the hypotheses, so he could try to figure out what went wrong and caused this fire. And you know what he said about that? He said, I didn't take any evidence because it had no evidentiary value. You see, there's that half-truth again that Ms. Zuderman has been talking about. You're right, you didn't take any evidence because you didn't look to find any evidence. When you analyze what he's doing, look at it in terms of his credibility and the high burden of proof. If you have any reasonable doubt about any of his opinions, especially when he lied to you, that's all you need. And when you have one reasonable doubt, ladies and gentlemen, about any issue, your job is done. Your job is done once you find one reasonable doubt. There's only two questions, really. You're going to hear, I'll tell you about the verdict form and first-degree felony murder, first-degree murder, second-degree murder. It's all about, did she set a fire and was it intentional? That's it. And you remember, well, we'll talk about it in a little bit, but as I said, one of the jurors was we were talking about half-truths. When my kids, I think they're lying to me, I just keep pressing, and then I get the answer. We kept pressing, Leroy, and then we got the answer. So I want to look at these experts in this case, because this is very important. I brought to you Bob Trenkle. Bob Trenkle is almost a 60-year veteran. Got born and raised in Detroit, cut his teeth in Detroit, literally the murder arson capital of the world back then. He has trained people, taught people, tested, been on committees, and what did he tell you? He spent 2,000 hours in this case, 2,000, over about 10 years. And when I asked him, how much you charge? Like $250 an hour? And then Mr. Blair came up, he couldn't wait to do the math. And he said, I'm not charging anything in this case. I think there was a question. If you're not charging anything, this is America after all. You must have a personal relationship with the family, with Linda Stermer. There is no relationship. He spent 2,000 hours in this case. He knows every piece of the evidence. He knows everything that Leroy did and Shinsky did. Leroy spent less than 6 hours on the scene and developed his report. You know, he spent more time testifying, defending his opinions than he spent on the scene getting his opinions. And when you think about this, these are real questions that need to be asked when you go back to the jury, these kind of devil's advocate, cynical questions. Mr. Shinsky is a veteran, way more experienced than Mr. Leroy, taught Mr. Leroy. Mr. Shinsky was actually at the house, as you saw, same time Leroy was, same week, did the excavation, did an investigation, why didn't they hire him? Why didn't they hire Mr. Shinsky to come in and tell us how good Leroy's opinion was and his methods? Maybe because Shinsky said, I did the excavation, and he would have known that Leroy lied. And the other thing is, Mr. Shinsky was asked to read this interview. Remember, read nothing but a transcript, bored the heck out of all of us. He's a fire origin and cause guy. He determined the origin and cause. Why didn't they hire him and ask him his opinions? Maybe because he disagreed with Mr. Leroy. And if you think there's any chance that's supported by reason and common sense that Shinsky disagreed with Leroy, that's an intentional fire, and maybe he determined based on all the damage that you can't just get every scene. It's undetermined, like Mr. Trinkle. That's why they didn't retain him. That's why they didn't hire the second most experienced guy who you saw in this case. And you know what? Greg Stormzan was with him. You remember he was his partner on that excavation. Stormzan said, well, you got to document so people can understand what you did. And it'd be the guy who was supposed to, I was just assisting because it's not my jurisdiction. He's the one who's supposed to take photographs. He's the one who's supposed to report. He didn't. You can't just omit this stuff. And when you think about this poor excuse of I was tired and I forgot, did you forget to write a report? Would you forget you were tired when you were writing a report and left out the excavation? Or maybe you didn't do it. Maybe you didn't do what you said you did under oath to us. If there's any reasonable doubt about Leroy's methods, how he failed the scientific method, anything that's supported by reason and common sense, no matter how small, that's reasonable doubt. And when you get one reasonable doubt, you're done. Not guilty. By the way, Mr. Leroy really kind of has an inherent conflict of interest when you think about it. He's up here defending his own work, and nobody's defending him. So like I said, he spent more time in the last 18 years defending what he didn't do than he spent getting the evidence. Follow the science, ladies and gentlemen. When you look at what was done here by Leroy, follow the science, what he collected, what he analyzed in 2007, and not what they're trying to suggest, well, so-and-so backs you up on this in 2024. That's not when he did the investigation and the lack of excavation. 2007 is when you hold him to the evidence that he collected and his analysis. Follow the science, follow the objective evidence. We brought you objective evidence. And by the way, defendant has no burden of proof. We don't have to show you anything. We didn't even have to call a witness, but we did. Called Mr. Trinkle. We called Dr. Z, who said this is a 5-mile-an-hour impact. We'll talk about that as it gets to whether Linda Stermer intended to do anything. But let's talk about the reasonable doubt in this case, starting with, as I said, Mr. Leroy's conclusions. And so because I didn't want to write it on the board, because my handwriting kind of sucks. Here, Leroy's opinion. Opinions are not reliable. Garbage in equals garbage out. And there was a whole lot of garbage in what he didn't do. You can't trust his opinions because you can't trust his methods because he didn't do it. He didn't comply with 921. He didn't comply with the scientific method. Did Leroy rule out an alternate area of origin? You remember, Mr. Leroy agreed with me, his living room here is about the size of this courtroom, all the way to the bench. Sometimes, as you saw NFPA 921, it says, sometimes the damage is just too much and the area is too big, and you can't make conclusions. You heard Mr. Trinkle. Ideally, You're trying to get to a point of origin. It was the back of the toaster. It was the electrical outlet. The bigger you get, the worse your reliability of your opinions are going to be, because there's just too much. And by the way, when you look at this and you're considering reasonable doubt, think about this. I stood here. Could the fire start here? Don't know. Could the fire start there? Don't know. Could the fire start there? Don't know. He can't tell you the where. If he can't tell you the where, you can forget about it. Because remember what NFPA 921 says? If you're not in the right area of origin, you can't find the cause. Because the cause is going to be in the area of origin. But if you don't look, and if you don't excavate, you will never find it. So then we talked about alternate areas of origin. Remember that chimney chase? And Mr. Trinkle said, the chimney chase, you heard from Cassandra Grigg, one of the witnesses yesterday. She talked about, first of all, how everybody talked about this house was unfinished. The whole living room is OSB press board, subfloor with a couple throw rugs. And the chimney, the surrounding area, was press board. You didn't hear them bring anybody to say it wasn't. They could have asked the two boys. They had them up there today. What about the chimney? They didn't ask that question. There's a reason they didn't ask that question. They didn't want to hear it out of their own witness's mouth. Could the chimney chase reasonably be a possible area of origin? Well, Mr. Trinkle told you it's consistent with the witness reports of a fire from the back rear of the place, flames shooting out of the roof, chimney chase. That chimney chase is 2+ stories high, and if you have a problem in the chimney from the flue, which you saw the rubble you didn't even analyze, then you can have rubble pouring down, and by the laws of physics, things don't drop straight down. They go in arcs. They go out and down, in an arc. And when you have a wall collapsing, that would be consistent with getting Todd in the living room. That would be consistent with his burns on his hands. And that would be consistent with a pretty sudden fire and him screaming. So we don't have to prove that it's the chimney chase. We're not here to prove that the chimney chase is where the fire started. He can't rule out the chimney chase could logically possibly be the area of origin because he didn't do the work. And if you can't rule it out, that's reasonable doubt. Let's look at the next one. Gasoline was on sweatpants not related to the fire. Can he rule out that maybe the gasoline he found on the sweatpants had nothing to do with this fire? Well, you remember his testimony? At least he was candid with me, because I had his old testimony from 4 years ago. He has no opinion on whether the gas on the sweatpants had anything to do with this fire. He said, I don't know how it got there. I don't know where Todd was when it got there. I don't know when it got there. I don't know when the last time the pants were washed. I don't know any of it. So finally he was candid enough, because I had him trapped, to say, I don't know. I have no opinion. Well, that's the whole linchpin of his whole gasoline in the house, because he admitted there's no gasoline in the living room. None was found. None. If he can't rule out that the gasoline has nothing to do with this fire, then you have to return a not guilty verdict, because that is reasonable doubt. That's the whole basis of his opinion. I'm sure you folks have notes on that. Now, this is important. The other thing that can cause reasonable doubt is, do you remember when I was asking him about his opinion, he relied on Linda Stermer and her testimony about being in the laundry room and running upstairs when Todd screamed. He was upstairs, she's downstairs. You remember, you heard a lot of talk today about all the inconsistent stories. What you've heard from every single witness who talked to Linda Stermer is that she was downstairs and Todd was upstairs when she heard this horrible scream and he was on fire. And she ran upstairs, and then her world turned upside down. So, my easel finally. Todd was upstairs. Linda forgive me, that's how my mom used to draw her when I was a kid, was downstairs. She was downstairs and had to run upstairs. Even Sergeant Leroy agrees with the obvious, you can't be two places at the same time. That means when he caught on fire, she wasn't there. She wasn't with him. And the interesting thing is, oh, wait. Interesting thing is, when Mr. Blair apparently realized this is checkmate on reasonable doubt and where the fire started and the cause of the fire, he started asking, well, isn't it possible that maybe she could have poured gasoline on him and ran down the stairs and there was all these fumes and she didn't get any gas? She didn't get any gas on her after doing that? Testing to 0.0005, not a drop, not a speck on that high-tech machine? No, there's no such thing as possibility. You heard every legitimate expert say, we don't guess, because guesswork masquerading as expert opinion testimony is junk science, and it's frankly unethical. We don't do that. So this idea of they'd like to show possibilities, you don't deal in possibilities. You are the judges of the evidence. But the evidence from their expert, I'm not an expert at fire science. You're not presumably an expert at fire science. You have to rely on the evidence that you heard from the witness chair. And the evidence from Leroy and Mr. Trankel was she was downstairs, he was upstairs. She wasn't with him. If there's any reasonable doubt that she had nothing to do with the fire, not guilty is your job. What's another reasonable doubt? No evidence of an ignition source. Let's talk about that for a little bit. Because you don't collect any evidence, he couldn't find any evidence of an ignition source. You remember we talked about NFPA 921 and the causal factors. Causal factors, if you'll recall, you look at your notes, are you have to have an ignition source and you have to have a first fuel. Ignition source, what's the thing that made something catch fire? Sure, first fuel. What's the first thing that caught fire? And most importantly, how did 1 and 2 come together? He didn't have any evidence of an ignition source, so he supplied one and said it's an open flame. Could be from the fireplace, could be from candles, don't know. Well, he didn't rule those out either. And then he said gasoline, but see, this is circular, because he said gasoline on the sweatpants, which he's admitted he didn't know how long it had been there, means there's gasoline in the house. That's completely illogical. He didn't have a first fuel. And he certainly couldn't put 1 and 2 together to tell anybody what caused the fire. How did the first fuel, even if it was open flame, 2, gasoline, how did it come together? What's the first thing that happened? Doesn't know. What's the second thing? Because you have to, as an expert, you have to do this. You have to say, this is the first thing that caught fire, and based on our training and experience, We know this, the fire propagated this way. This caught fire, then they caught that fire, and they caught that fire, and caught that fire. You tell how the fire started and how the fire progressed. He couldn't do that because he didn't do step one of the scientific method. He didn't collect the data. Garbage in equals garbage out. And when there's garbage for the out because of garbage from the in, that's reasonable doubt. Doubt calls into question the confidence in his opinion based on reason and common sense. Reason and common sense tells us you can't be where the fire started if you're downstairs. He couldn't give us the how. Frankly, he couldn't even give us the where because he doesn't know within this huge area of origin where the fire started. Number 9. Since he couldn't tell us the cause, he certainly can't tell us the classification. Accidental fires, natural fires, lightning strikes, undetermined, and incendiary. Incendiary is the only classification that supports a crime. And if you don't have a cause, you can't have a classification. If you don't have a cause, the only intellectually honest thing you can do with integrity and honesty is say, it's undetermined. And there's no shame in that. Because sometimes fires are just too total. The damage is just too much. Did he rule out an electrical or mechanical cause of the fire? Well, he's admitted he's not an electrical expert, and he's admitted under oath that he didn't collect anything. So how could he rule something out that he didn't collect? And what does he do? He explains that, well, electrical fires in walls, they start small and slow, and so this is why this whole able-bodied thing comes into play, and an able-bodied person, if it was electrical, could figure that out and escape. Electrical fires in walls can explode all the time. Happens all the time. Did he exclude and rule out a mechanical cause? The flue. You saw all that damage to all the flue pipes. That's why we bring in people and they look at it and they try to see what could have been a failure of the flue, and that's how things started in a chimney chase. He's not an expert, he said that. He didn't collect the data. You saw how Shinsky laid out the stuff like you're supposed to do. What did Leroy do when he was tired and it was a long day? He threw the stuff in a pile in the back of the house. And forget about 123. Nope, 30. We'll get it. You remember Shinsky's photo. He just piled it. There's no analysis. There's no thorough investigation. There's no thorough, rigorous testing, which is what NFPA and a scientific method say you have to do. He just threw it out so he could go home because he was tired. And you remember I asked, why didn't you just come back the next day? Didn't have an answer for that. Wouldn't you have told your young associate? Nothing wrong with going back. Why didn't you go back? And why didn't you write a report? And why didn't you do what you were required to do in this death case? Then he didn't rule out contamination of the sweatpants. Remember, he found 3 hours later Todd Stermer, and he smelled gasoline. We'll talk about that in just a second. He smelled fuel. I shouldn't say gasoline because he said, at least he was honest, fuel is fuel when you're smelling it. I don't have a super nose. So he smelled fuel, and that's why he took the sweatpants. But remember, he's there 3 hours later, and this is the final point of arrest for Todd Stermer, after he's been taken in this boat to here. So, if you find in here, you have to analyze, could there have been a transfer through the boat, or you remember, Matheny put clothes on him, a bunch of clothes, and they found that here, right? Could there have been a contamination from there? It's not whether there was, it's whether he can rule out the logical possibility that there was. And how do you do that? You use the scientific method like all scientists do, like all professionals do, and you collect data, starting with the boat, working backwards. I asked him, did you use a rag, anything? No. Did you talk to anybody? No. Talk to the family? No. That's all data. No. I don't even think he knew there was a boat involved. So he couldn't collect the data, so he couldn't do the rest of the steps, so he couldn't comply with the scientific method, which means that his methodology is garbage, so any opinion that says that didn't matter, that's garbage too. If he didn't rule it out, that's reasonable doubt. These are 11 different things that I've come to. When you go back, you were taking a lot of notes, you might find more. When you think about all the evidence, you might think, let's look at that. Did he consider that? Maybe that's reasonable doubt. You might find more than I did. But you don't take possibilities. Pros don't take possibilities. So when Ms. Zuderveen, like Mr. Blair, says, was it possible that this happened? That's not evidence. That's speculation. That's guesswork. Experts don't do that, and you can't accept that as valid evidence. Not only was there Mr. Leroy's shortcomings, but you remember a lot of the police witnesses who testified. Oh, let me segue here. Let me just back up just a little bit. Do you remember, all of a sudden, remember this fire chief who had been retired for a lot of years, and comes in, he said, I've done hundreds of fires. And all of a sudden he remembers, yeah, I smelled fuel too when I was there. He didn't write any report 18 years ago. He's never said that ever in any document. But he admitted I met with the prosecutor, and we talked about what my testimony was going to be. So it's kind of weird that all of a sudden people 18 years later are saying things that they never said and never wrote. So when you consider credibility and the credibility of the witnesses as you're analyzing whether there's reasonable doubt, think about that. Every law enforcement person who came in and said that they smelled fuel at the scene on Todd Stermer never said it before and met with the prosecutor to prepare. One more thing I did forget. There was talk about the construction of the house. And this is real important because as you're analyzing, how could the fire have started? Could it have been an accident? Remember Brad Stermer, the older brother? He said, I was in college, and remember we had that yellow house that was my dad's, and Todd was the main guy working on it. And he said, I'm a handyman, and I'm good at it too, but we didn't have any money. I think the phrase was, we were scraping nickels together to get it fixed. And he admitted, we didn't use the best equipment, the best components as we were doing the house. And 5 months after they finished, with Todd at the helm, being unlicensed, that place burned. And he said that was an accidental fire. Well, that can happen when you don't have licensed contractors, and good as you may be as an amateur, You're not a licensed electrician, you're not a licensed mechanical person, HVAC, nothing. That can happen, and you can't rule out that that happened in this case, and we know why. Because it took, what, 6 years for this house to be built? You're scraping nickels if it takes 6 years to build a house. You're doing what you can when you can afford it. You heard, and maybe it's because of the horses, but you heard they were having money troubles. That's why they didn't build it. That's why they were scraping nickels. And he was at the helm. And you heard, not only did you hear from all the people who have been in the house about all the exposed wood, which is why it would have gone up so fast, because it was a tinderbox. Then you heard the last witness we had, Rich McGrew, who said if you don't get a final electrical and a final mechanical, and we don't certify it as good for final occupancy, it is a unsafe house. Why unsafe? Because you can have fires. So you're not here to supply evidence, you're here to address the evidence that was given to you. And in that sense, you can't rule out that because of poor construction, this could have been an accidental fire. And the fact is, because it's a tinderbox, that also explains the speed of the fire. But at least Leroy was candid enough when I questioned him and caught him in some demonstrable untruths, that he said, yeah, I didn't know how the house was built. I didn't know that it had OSB flooring. I didn't know that there was no final certificate. I didn't know that it didn't have final inspections. That's all data that you can collect that's available. You know who collected it? Len McHugh, the property adjuster, who, by the way, Linda Stermer asked him, why are you here? Because we don't have insurance. We'll get to that in a second. But he's the one who collected the available data, he said, from the building department, which is what Leroy could have done, but chose not to. Garbage in equals garbage out, makes it unreliable. It can't be trusted. And if it can't be trusted, that's reasonable doubt. Now, let's talk about the police work in this case. In this rush to judgment, where they first, I will say, they got misled by Leroy, who called it an incendiary fire. So in their terms, in police terms, that's an arson. And we have a guy who's dead and we have blood on the bumper. Now, their rush to judgment resulted in all kinds of sloppy work. First of all, this missing video that we're talking about, which would have helped anybody, including a defendant who's under arrest, determine how the fires was spreading, that's gone. You heard Cynthia DeLoach, the gas station attendant. I asked Maciaski, you got the cash register tape and the video from the place in February of '07, a few weeks after. It's stuck in your drawer for 2.5 years. And is that proper protocol for property preservation? I'm not sure what the protocol was back then. You're a veteran cop. Your command staff. You don't know this? Or is this just another half-truth? Mislabeled evidence. Remember that coat that was in the silver can that turned out to be Mike Matheny's coat, that red checkered one? That was labeled Todd Stermer, which helped Leroy determine, well, everything that's tested positive for gasoline is Todd Stermer's. Therefore, couldn't be any contamination. He didn't realize until later, oh, that's Matheny's coat. And he didn't rule out the contamination from Matheny's coat or the boat. If we didn't rule that out, that's reasonable doubt. Witnesses weren't interviewed for 2.5 years. Cynthia DeLoach didn't get interviewed until 2.5 years later, June of 2009. And remember the testimony from her? I knew Deputy so-and-so, and he'd come in all the time. Have you talked to the folks? Have you talked to my bosses, whoever's running the investigation? No, nobody's come to talk to me. Remember Maciaski, who said, I got too busy and I forgot. Everybody seems to forget here. He got too busy. He didn't go see her for 2.5 years. When you look at it with a bit of a jaundiced eye, this other detective, if he's going to Cynthia DeLoach, what'd she say, every month, every 2 months or so, have you talked to us? Have you talked to our guy? Have you talked to our guy? You think he's not going back to the department? Why don't you talk to this woman? She's got evidence. He didn't do it. And by that time, she forgets, because you heard her testify. I don't know if Linda Stermer was pouring gas. I didn't know, she should have said, I think she was, but I didn't see a container. Now, think about this, because I want to talk about this red gas can that was found in the front yard. And they're trying to relate it, one to the fire and all the way back to Cynthia DeLoach. This gas can that was found by Leroy, you can see, has a broken spout. He didn't know how long it had been there. This gas can they try to relate to and make this big conspiracy by Linda Stermer, she went and bought gas in the morning and she put gas in the truck. Linda Stermer is all about 5'6". Chevy Blazer, remember the talk was the hatchback. 5'6" woman doing this into a gas can, and you didn't spill a drop of gas. You didn't spill any gas. You didn't get it on your clothes. You didn't get it on your hand. How do you pump $11 of gas, roughly 4.5 gallons, into a 1 gallon tank? You don't, because there was never any gas being pumped into a gas tank. And how do we know that? Because Trevor was honest enough when he testified to say, remember when we went to the mall in the Blazer? I didn't smell any foul smell. You know what gas smells like, right, Trevor? Yeah, I know what it smells like. You didn't smell anything, did you? No. Anybody, including me, when it's time to use a snowblower and I got to go to the gas station with my gas can, I put it in the truck of the SUV, it smells. And I may not spill a drop. But anybody who spilled gas on clothes or their hands, it reeks. For a while. So when you think about credibility and what is trying to be portrayed as this grand scheme, reasonable doubt. Was this even connected? No. The most telling evidence is their expert, Leroy, said, I have no idea. It has anything to do with it. So what you're being told by the prosecutor is some theory based on no evidence, trying to connect dots. But it's a bridge too far, a road too long. You can't connect dots because all you're doing is guessing. And you as a jury have to evaluate the evidence, not the talk of me, not the talk of Ms. Zuderveen. Judge will tell you that. What we say is not evidence. What they said was evidence. Leroy said, no idea. No idea. Now, we have all kinds of reasonable doubt, at least 11 things, just in terms of how the fire started or where the fire started. But now I want to talk about the second part of it, intent. Did Linda Stermer intend to set a fire? Let's look at the objective evidence. Then we're going to talk about all these 5 ways that Ms. Zuderveen said Linda Stermer tried to kill her husband that day. 5 different ways, and we'll analyze that against the objective evidence we have. First, the thought and the theory by the prosecutor is Ms. Stermer struck Todd in the van, therefore she intended to kill him. Well, let's look at that through reason and common sense. And if you lack confidence by using your reason and common sense, that's reasonable doubt. You heard the 911 tape.
Yeah, oh my God, she's outside. I don't know if people did it. Oh my God. She's outside now? She's outside, but she's screaming something to my boyfriend. Okay. Can you see what she's screaming? I know. I don't know. I'm trying to get here. I don't know where she is yet. She's freaking out. Oh my God. Can you tell me how you still with her here? Are you able to go outside with your cell phone and see? Yes. Would you find out if anybody's inside or not? Is there anybody inside? Is there? Oh my God! Yes! There's no one inside. Calm down. We got the fire department on them. Okay. There's someone inside.
That, as you know, was Connie Calhoun, and you saw her stress level, the chaos she was going through. She wasn't in a fire. Her spouse wasn't on fire. Her house wasn't on fire. And you saw how she was. And by the way, every person who testified here from law enforcement or people like Connie Calhoun and Mike Matheny and Dr. Masali all testified she was hysterical. She was beside herself. Now, she would have to be the greatest actress in the history of Hollywood. Meryl Streep would have nothing on her. And by the way, remember the theory that Ms. Zuderveen just told you? She was driving down the driveway. She was escaping. Let's look at that through reason and common sense and see if we doubt that statement. Who is a mastermind who supposedly got gas in the morning in a gas can to torch a place, scooted the kids out, and then is escaping, as she said, and escaping with no shoes, and escaping with no coat in January, and is escaping with no cell phones in January, and is beside herself hysterical? All it takes is a little bit of doubt based on reason and common sense. And anybody who heard that 911 call cannot come to any conclusion other than she was shocked by the fire and she was in a state of panic. And you heard Bob Trenkle. Firefighters, police officers, military folks, they train so they can have muscle memory when the stuff hits the fan. She's a middle-aged woman who never engaged in any of that, and she acted like it. like she'd lost her mind, because it's fight or flight. And she ran, but she wasn't escaping. She was trying to get help. And it is pretty darn cynical to listen to that 911 call and to say she was trying to escape this mastermind was. Now, there were talk about valuables in the house. One of the things you look at, as any cynical person like Willison would be, is if you're going to torch your house, I want to make sure my pictures of my kids and all my valuable stuff and all my guns and everything else are out of there. Then I'll torch the house. Remember, Trevor's baseball cards that were so valuable to him were found in the basement in the rubble. And you heard from Tina, Benny, and she said, my husband and I, we had this handmade little sifter, and we found a wedding ring, Linda's mom's wedding ring, valuables that were in the rubble, by using equipment that Scott Leroy should have been using, that he has, that they use. So this idea of you hide valuables, reason and common sense. And reason and common sense tells you if you have a financial motive, you kind of know you had insurance. Len McHugh said, she asked me, why are you here? We don't have insurance. Our insurance lapsed. This is the financial motive? This is a get-rich-quick scheme by this mastermind? There's no intent. There's reasonable doubt as to every bit of intent here. Oh, then let's talk about these 5 ways, the 5 best ways to kill your husband in the same day. First, she tried to drug him, then set a fire. Where'd that come from? Kate Fox with a coffee cup, remember? But Kate Fox told us, Linda Stermer said, I put the coffee cup and I didn't drug him because he was already on tranquilizers. Let's look at the objective evidence about that. Dr. Markey told us in no uncertain terms that there are no drugs in the system. And when we talk about who's being square with you and we want to have credibility, Dr. Markey said the remnants, the metabolites of hydrocodone were in the urine. That's not active. There was nothing but caffeine in the bloodstream, the active ingredients. And the metabolites that are in the urine, which last longer, were explained by the medical records that we just admitted today from the family physician who prescribed Entex HC, a narcotic for the ear infection that has hydrocodone. Dr. Markey admitted hydrocodone is consistent with taking this cold medicine that the doctor prescribed. So when we're talking about what the evidence represents, like I said, thank God what we say is not evidence. You can rely on your notes and you can rely on the transcripts. Well, you can't rely on it, I can. And also Ms. Stermer said that Dr. Markey had no opinion as to whether the skull injuries, the lacerations on the head were related to the van versus something else, which you're suggesting is a frying pan. Dr. Markey said on page 18 in his testimony, those injuries that you saw to Mr. Stermer are consistent with having been run over and striking various undercarriage components, isn't it? Well, the injuries themselves, as I stated before, very well it could be to being struck and overrun and striking things on the undercarriage of the motor vehicle. That's his actual words, not what you heard he said. And you can look at your notes, because these are the actual words under oath. And it's consistent with Dr. Zachewski, I just call him Dr. Z, who is a renowned biomechanics injury mechanism expert with decades of experience working with brain injuries, who told you all of the lacerations and these skull fractures, it sounds bad, a skull fracture, A depressed skull fracture has been explained as you take your finger through some icing on a cake. It doesn't even hit the bottom of the bone. There's no linear skull fracture. There was no brain injury, as Ms. Zuderveen tried to suggest, Markey said. That's not on the autopsy. These are AIS-2 injuries, Dr. Z said. Moderate injuries. Not related. There's no evidence that it was related to a frying pan. So that's the first one. Drugs set them on fire. Number 2, crack them with a frying pan. Then set them on fire. Except that came from Dardita Gordon, who admitted to so much mental illness and on so many medications normally that she would have been, except she was in jail when she gave that statement. And she said, they don't give me my meds in jail, and I have memory problems. And guess what? She admitted that it was Detective Macioski who suggested, could it have been a frying pan? It was a jailhouse snitch. Yeah, I guess it could have. You look at all of this with a cynical eye, and when you're evaluating the witness's credibility, that's unreliable. That's not consistent with the physical evidence. We don't have to prove anything to you, but we bring you objective evidence, follow the science, follow the objective evidence, and you can't come to any other result other than there's reasonable doubt. And by the way, what devious mastermind who's going to torch the place and kill her husband spends the afternoon packing up Christmas decorations? What, an hour before I'm going to torch my place and kill my husband? None of this makes sense. Starting with all these witnesses who prepped with the prosecutor and all of a sudden change your testimony or hear new testimony. So frying pan is number 2. Setting the fire by itself, well, we already talked about that. That's clearly reasonable doubt as to where the fire started, no doubt as to Linda Stermer didn't have anything to do with it, and you didn't hear a single word from Mr. Leroy or the prosecutor that gas on the sweatpants had anything to do with Linda Stermer. Because if they had that opinion, it would have been front and center. It would have blown up on the wall 10 feet high. No opinion, your notes, you can pull them all. Nobody will find a note that says that. The gas on his pants, which he claims is the whole key to the case, that it had anything to do with Linda Stermer. 4, run them over after you set the fire. Well, you heard testimony from Dr. Z that it's a 5-mile-an-hour impact. And those injuries, you didn't see anything where he was run over by a 4,500-pound vehicle, no broken legs, no broken bones, rib fractures consistent with CPR, no brain injury, no skull injury, no nothing other than icing on the cake and some lacerations consistent with being run over at a low speed, as Dr. Z said, with a high load. High load is just, it's a 4,500-pound van. And Dr. Z's testimony is undisputed, because don't you think with the resources that the government has, if they could find anybody, and I mean anybody, to counter Dr. Z or counter Dr. Markey, that they would have? But this is the same group that's letting Leroy defend himself. They won't even hire Shinsky, because Shinsky's not going to go their way. And finally, the 5th way she tried to kill him that day was to suffocate him. So here she is in this panic state of chaos, fight and flight, and out of her mind, and she's yelling, Todd, Todd, stay with me. And what did they say? We think she was laying on top of him. She wasn't laying on top of him. She was trying to hold her husband and keep him alive. And if there's any little doubt that you have that's supported by reason and common sense, that doesn't require you to abandon reason, then that's reasonable doubt. And if there's reasonable doubt, you have to vote not guilty. There's no intent here. Clearly reasonable doubt as to the intent and lack thereof. I'm going to talk a little bit about the inconsistencies And of course, there were a lot. But you know what they were? They were details after she got to the top of the stairs, when her world blew up. While she was downstairs and calm, everything's consistent. I'm in the laundry room, and Todd is upstairs, and that was relied upon by Leroy in terms of finding the area of origin. It corroborated his physical findings. His physical findings corroborated her testimony. Nothing about these witnesses that they're bringing you is being corroborated. We talked about how Mr. Trinkle said how people train so they hope they can combat panic when the adrenaline is high in a stressful situation. And when you're in the jury room, I want you to think of this. A lot of people Monday morning quarterback and go, I wouldn't have done that. I would have jumped on my husband. I would have saved him. While you're having a cup of coffee in the jury room, or you're watching TV in 2020, I would have done this, I would have done that. You don't know what you would have done. What you would have done and what you could do in the situation are two vastly different things. So when you're thinking about what she was going through, you have to put it through the lens of this high burden, this presumption of innocence, and that none of us know, unless you've been in a fire and running out in your underwear, what people go through. I'll talk a little bit about their witnesses, not much, frankly. Certainly not going to go through every witness of theirs. Let's talk about, we talked about Dardita Gordon. Let's talk about Kathy Ilge, who's the one who said that she talked to me about the coffee cup and the drugs, and that she found jewelry in the van, Linda Stermer's van that she drove, remember, within a week or two of the fire. And in the center console was jewelry, which to a cynic would mean you're kind of squirreling away stuff, the valuables, because you don't want them to burn up in the fire. Well, look at the objective evidence in this case. First of all, you remember Kathy said, within 2 weeks of this, I'm in the van. And in the center console is the jewelry. Do you remember the van was confiscated by search warrant that night and examined the next day? The picture of the center of the console of the van, as Macioski showed, taken on the 8th the next day, there's no jewelry. And Macioski, who's supposed to put a detailed report together anytime you do a search warrant, it's the property you take and confiscate and take into evidence, never mentioned jewelry because it didn't exist. And here's the kicker. This is a murder investigation. What police department in a murder investigation involving a bloody van is giving the key evidence back to the family in a week? Think about that. When you're back in the jury room and you're thinking about the credibility of these witnesses, no police department. This is a murder investigation, and that is a critical piece of evidence. You don't give it back to the family. Oh, the other funny thing, among many, is that she said, let's strike that. I'm going to go to Kate Fox. But Kathy Ilg can't be believed. Testimony is unreliable. And for them to put somebody who would talk that crazy and that to give testimony that is so demonstrably false by the evidence, you have to wonder as you start to think about these weird things, why are they putting up these witnesses to talk about things that would be impossible, that are demonstrated to be impossible? Maybe because they can't talk about the fire. Maybe they want you to dislike her so much you ignore that there's no evidence of a fire being caused intentionally. And nobody can prove it, so we want you to dislike her. We don't want you to think highly of her. She had an affair. She said this, she said that. She treated Todd badly. Because we don't want, in 90 minutes, they talked 5 minutes about the fire, why we're here. And in the 5 minutes, you heard one sentence. Leroy said, it's consistent with an intentional fire. She didn't tell you about the evidence that supported that. She didn't tell you that we don't know how the fire started. We want to give you the why. We want to give you the motive. But we don't want to tell you how, because we can't. Let's talk about Kate Fox. Kate Fox came in here, dressed really nice, and talked about a coffee cup and the drugs. Remember, we talked about Dr. Markey, how he blew that apart. But the other thing that struck me is you were supposedly best friends with Linda Stermer, but because her sons lost their father and she had to take care of them and she had to switch a shift, you felt like she betrayed you? And so maybe you have an axe to grind. And when you look at her credibility, let's measure this against the credible evidence and the objective evidence. Linda Stermer, while she was carrying on this affair, told me to close up her post office box because her husband was going to find out. The federal government allows a stranger to come in and close somebody else's post office box? Really? They want you to believe that? This is who they're putting up as a credible witness to talk about she confessed, she did this. The objective evidence. When you're evaluating credibility, look at what's out there that can't be true. And finally, Trevor Stermer, Trent Stermer, they came on. They both disliked the mom very much. They both only started calling her Linda instead of Mom after she got charged in 2009. And they were both living with Grandma Stermer before the trial and after the trial. Just take that in consideration. I tried to be as nice as I could, but I had to point out all the inconsistent statements under oath, and it probably bored you because every 30 seconds I was going, remember you're under oath, right? And you swore to tell the truth, and you did tell the truth. And eventually, after you ask so many questions, they go, yes, I was telling the truth when I said Mom was acting normal that day, which would be consistent with Mom's wrapping up the Christmas decorations and putting them away an hour or two before she's going to torch the place. You can't have it both ways. You can't have it both ways. You can't be this diabolical killer, master planner, so they can say that it's premeditation, and on the other side of the coin, you're saying she's going around wrapping up the Christmas decorations. And by the way, remember they said, not only was Mom acting normal, but if I'm going to torch the place, I'm not going to tell my sons, all right, see you when you get home. I'm going to say, don't come home for 5 hours. Or maybe you need to go to another friend's after you go to the mall. You don't say, just come home. I'll see you when you get home. That's not somebody who's premeditatingly going to murder her husband. And when you talk about, you're going to get a jury instruction about premeditation, it's going to be, there has to be some time connection involved with premeditation. Everybody has said a lot of things, maybe to their spouse, to their friends, or whatever, that they say in the heat of the moment, or tell their friends in the heat of the moment. But if this happened on January 7th, and she's telling Kate Fox this in the summertime before, that's not premeditation. That's not evidence of premeditation. There was no evidence of premeditation on January 7th. None. Talk about Chief Leach and all of a sudden his sudden memory. Oh, by the way, you do remember that Trevor and Trent also met with the prosecutor and all of a sudden remembered some things that they had never said before. Verge Franks, one of the police officers you saw first on the scene, smelled gas But that's after Matheny's coat is on Todd Stermer. Didn't have a report, never said it before. I want to just kind of wrap it up this way. In order for them to obtain a guilty verdict, they have to show that the actions of Linda Stermer caused the death of Todd Stermer. The actions can only be she set the house on fire because he died of burn injuries. I was thinking about showing you the video of the burn of the sweat. You've seen it. You know what happens to polyester pants. And the question was, well, he was on fire, how did the pants not burn since they burn so easily? And you heard Mr. Krenkel, who cited NFPA 921, Chapter 24, that said, we all know, well, we don't all know, but skin burns at about 110 degrees, 108 degrees. You get 108 degree temperature, your brain cells are burning and dying. Clothes, as it said in 921, ignition temperature, pretty much the lowest, is about 450 degrees. So that can explain the thermal burns, which he said, these were not contact burns. People who die in a fire when they've been immolated, they look like a burnt hot dog. That wasn't this case. This was thermal heat burns, which explains why the pants weren't burned, which also explains that there was no gas on the pants in any amount that could be related to anything with this fire. Because I wear my sweats Friday, Saturday, Sunday, Monday, it doesn't matter. People do that. You can't tell how long the sweats had gas on them, the last time they were washed, where he was. If he can't rule it out, it's reasonable doubt. And finally, I told you have rights. Linda Stermer has been fighting this since I've been with her for 6 years now. And Skip and our team. So now, excuse me, I'm going to turn her future to your hands. Follow the evidence, follow the scientific evidence, follow the objective evidence, and understand how high the burden is to achieve beyond reasonable doubt. Clear and convincing evidence, a firm and definite belief that any proposition is true, not good enough. If there is any doubt that's supported by reason and common sense, where you don't have to throw out reason, that's reasonable doubt. You deserve to be on a jury that holds the government to that burden that our founding fathers set forth. You deserve to be on a jury that holds the government to that high burden on every single fact that they need to show to prove those elements. They can't check a single box. Forget 3 boxes or whatever she was talking about. There's no evidence to suggest that this was an intentional fire. It was such a shoddy investigation by the fire sergeant, fire marshal, that there's nothing but reasonable doubt. People can't be 2 places at one time. And finally, they have to rule out reasonable doubt for every single element. You know why we're here, really? Is because Sergeant Leroy mailed it in. And 18 years ago, he destroyed Linda Stermer's life by mailing it in. So when you're deliberating and you have a conviction, and we said you took an oath to not mail it in. You took an oath, if you have a conviction, to stay as long as it takes and stand up and not be bullied by somebody who maybe wants to go home on Friday and doesn't want to come back, because I missed 3 weeks of work already. There is too much at stake. A person's freedom is at stake. Don't mail it in. Todd Stermer mailed it in. Leroy mailed it in. And you know what? He not only did a disservice to Linda Stermer, but to Todd Stermer and to you. Return a verdict of not guilty on all counts, or the verdict form that you're going to see. I didn't have a chance. We just got it this afternoon. Didn't have a chance to blow it up on a board. Possible verdicts. You may return only one verdict on each charge. Premeditated first-degree murder, not guilty. First box. 2, felony murder, the arson, not guilty. Everything depends on whether there was a fire that was set intentionally, and was it set by Linda Stermer. If there's no arson, there's no crime. If there's no crime, there's no premeditation. I'm going to put this in your hands to do your job and hold yourselves to your oath. Thank you. Not guilty.
Thank you, Mr. Mueller.
Housekeeping time, Your Honor.
Break. Okay, I have a juror who needs a break, so we'll take a 10-minute break.
Thank you. Mr. Champion.
A snack bar? Snack bar?
How that taste, Judge?
Jay says, yeah. Straightening up the place. Okay, we're back on the record. Any matters to address before we bring the jury in for rebuttal?
No, Your Honor.
Mr. Mueller or Mr.
No,
Kell?
Your Honor,
Okay, we'll bring in the jury. Welcome back, jury. Ms. Siderveen, any rebuttal?
Thank you, Your Honor. I'm not going to address 2.5 hours of rebuttal, but I can't get up here and not talk to you about the misstatement of the law that was made by defense. First of all, judge is going to tell you you may not let sympathy, bias, or prejudice influence your decision in any way. That means sympathy for anyone, sympathy for the boys, sympathy for Sandy Stermer, sympathy for Ms. Stermer. It doesn't matter. That's not your job. Your job is to find out if the evidence presented checks the boxes and the elements are met. And sympathy does not play a role. I also want to talk to you about reasonable doubt. We have stated it over and over and over. And every crime is made up of parts called elements. Prosecutor must prove each element of the crime beyond a reasonable doubt. Defendant is not required to prove her innocence or do anything. If you find the prosecutor has not proven any element beyond a reasonable doubt, then you must find the defendant not guilty. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of defendant's guilt. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not imaginary or a possible doubt, but a doubt based on common sense and reason. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances. All his charts and going over the different types of burdens of proof doesn't change your burden of proof. It is based on common sense. It's not imaginary, it's not possible, but it's based on common sense. So get back grounded with what the judge is going to give you. He made several statements, I'm going to reference them as I just go through quickly, that all you got to do is just find one thing and you're done, your job's done. No, ladies and gentlemen, that's why we presented all of the evidence. Your job is to take all the evidence, all the pieces of evidence. If you were to take out the fire inspectors, and we just brought in Dardita Gordon that said she cracked him over the head with an object, you found lacerations, you saw the blood on the van, you found the gas on the sweatpants. If you believe that testimony, you could find her guilty. So each individual person that comes into you is but one piece of evidence. Mr. Trinkle is one piece of evidence. Scott Leroy is one piece of evidence. Your job is to evaluate all the evidence. All the evidence. Mr. Leroy didn't do anything wrong. He didn't ruin, I see your face. He didn't do anything wrong by investigating this crime. He wasn't trying to destroy anyone's life. He's just trying to investigate a crime. He got up there, he honestly told you, you know what, I do things differently today. I should have taken more pictures. I should have done more. He's one piece of evidence. But the interesting part about that is that you can still look at all the other evidence to corroborate some of the things he found. And that's what you need to do. You need to look at. Mr. Trinkle didn't even say that there was a different place of origin other than in the living room. Mr. Trinkle was then wanting you to pinpoint a very specific place of the living room and said, if you can't pick that one little spot in the living room, you can't even declare it an arson, ignoring all of the other pieces of evidence that you guys have been presented. The witnesses that were attacked, what you can also do is you can look at the witness testimonies corroborated by other witnesses. So when you have one witness saying something, and it's corroborated by another witness, and it's corroborated by another witness, that may start to make you feel that that information is credible. Kate Fox identified Chris Williams, told the police about where he lived. They went there and he said, yeah, he's having an affair with her. It's corroborated by more than just one person. Even Tina Benny corroborated that there were photos at the scene. You can look at that to say, maybe what Kathy Ogwa said is corroborated by somebody else in determining your credibility and the credibility of the witnesses. That's your job. Your job is to determine the credibility of the witnesses. The boys explained their inconsistencies. They told you this is really the first time, it is the first time that they've been able to come in and testify under oath. They explain those inconsistencies. And you can take that and you can weigh that in terms of judging their credibility. It's you that decides the evidence. If it were just, we have an arson or suspected fire, and we hire an arson investigator and he says it's undetermined, okay, I guess there's no crime, we can all go home. That is false. That is false. This is an entire investigation. This is an entire investigation. Even Mr. Trinkle told you this is not a legal determination. That's why you're here. He is one piece of evidence that you can consider. Just one. All the evidence that we presented ties to Linda's intent. Her actions support murder. Her actions support premeditation. These are things that are supplied to you to be able to determine if those boxes are checked. You're not simply here as a battle of the experts. That's not what your job is. That's not what your job is. Your job is to evaluate all of the evidence. His expert, Mr. Trinkle, told you, well, first of all, he denied that if he'd ever been involved in a prosecution where there was an undetermined fire. So basically, if the arsonist is so good that everything's burned up, you can't prosecute? That makes no sense. That makes no sense because you're not even looking at any of the surrounding facts. He said he was never involved in a prosecution where it was an undetermined cause, on a fire. And then when Attorney Blair said, well, what about people versus in this very courtroom? And did you see his demeanor change? Because he got caught and didn't know how to answer it. And then basically said, oh, well, I've never been involved in the prosecution where my opinion's been wrong. Because I'm never wrong. He is one expert that you can judge his credibility and his findings. I never asked you for a pass. I asked you to hold me to my burden. And I told you that I wasn't going to bring in 200 people, anybody who'd been talked to, but I was going to bring you in enough evidence to prove the crime, enough evidence to check those boxes. I never asked you for a pass. I'm not asking you for a pass today. I'm asking you to take the evidence that you got from me, from this trial, from those witnesses that took the stand, in totality, and make your decision. There's no pass here. Like I said, you can completely rely on the witnesses that you believe. So if you believe Dardita, you believe the person who analyzed for the gas, you believe the person who then found the blood stains under the car, you've got enough evidence right there to make your decision. You determine who's credible. You determine what evidence is credible, and if that meets the elements. He stated, if there's one reasonable doubt, your job's done. You can all go home. No, I wish it was that easy. You have to consider everything and all the evidence. One reasonable doubt and you're done. That's a misstatement of the law.
It's a misstatement. It's absolutely the law.
I'll give these are closing arguments or arguments of counsel, but I'll give you the instruction on reasonable doubt, jury, when you go to the jury room, or before you go to the jury room.
If you have reasonable doubt about an element being proven, that's the law. Not if you just have one reasonable doubt about a particular testimony, particular witness. I wish it was that easy. You're not done. Your job is to evaluate all the testimony and all the evidence. He brought up that Linda was in the laundry room. She can't be her. She's downstairs. We talked about that. We talked about how the vapors could have ignited. We talked about a possibility of where that could happen. But you're also then relying on Linda's statements that she was even in the laundry room. A person who only says statements that don't incriminate her. So you can certainly consider that. You can certainly consider her credibility with everything else and all her descriptions, and whether you believe her or not. Counsel's asking you to rely solely on Mr. Trinkle. Asking you to forget that you're the jurors, you're the judge of all the evidence. No one person determines the verdict. And I mean by that, I mean no one witness. It's taken as a whole, and what you feel elements are met. Possibilities. Said you can't consider possibilities. Well, you can consider possibilities if they're backed up by other evidence. You consider the possibility that that gasoline was purchased by her because it's backed up that she bought it. You can consider the possibility that the 1 gallon gas tank can was used by her because it's a possibility, it's on scene. And you can consider it a possibility because there's no other reason that gasoline should have been on Todd Stermer. You have other evidence that talks about all the other clothing that Matheny had put on him did not test positive for gasoline. You have evidence that that duck boat never ever had an engine. You can use other evidence to make your determinations, and what would then lead towards a conclusion. You consider everything. He wants you to believe that Steve Leach came in and relied on Scott Leroy's report, and voila, there was gasoline, and so he smelled it. Well, you have other evidence supporting that there's gasoline on the clothes. You can consider that. Ladies and gentlemen, they lived in this house for 3 years. It took a long time to build, but they lived there for almost 3 years. No reported issues, no reported fires. And in the documents that you received on the building from the building inspector, there's several written letters by Linda of why they're asking for delays before they moved in. And they detail out Todd Stermer's knee injuries. It wasn't that they were saving up and trying to, put in the cheapest materials or buy as they go. Read her letters. The ones to the building inspector are in there. They're her detailing out how Todd hurt himself. And they had to take a break, and then they needed to restart. Either Miss Stermer is the most unlucky person in the entire world, or all these dots that he talks about lead to the next dot, and lead to the next dot, and lead to the next dot, and show that this is more than just an unfortunate, unlucky series of events. There's been lots of testimony that Linda Stermer becomes overly emotional, only shows emotion when she's pressed. She can turn on the emotion to avoid the questions. Connie is very emotional in that 911 call. What you may be hearing from Linda is that she's scared she just got caught. All she's doing is wailing. You don't hear her talking. She might be horrified at her own actions. Might not have expected everything to go on the way she wanted. Certainly been enough testimony for you to consider. She might be trying to cover her own tracks. Maybe doesn't want to talk to anybody, wants to play the part. She didn't hide baseball cards, wedding ring, gun. All that can be replaced. Those didn't mean anything to her. There was a little bit of mistestimony or misstatement. Ms. Fox said that she wanted to go to the house to find the cup because Ms. Stermer had put something in there. I think she said a tranquilizer. You can check your notes. But changed her mind. And she didn't want the police to find it. That's why you didn't find it in the toxicology. I doubt that Kate knew what the toxicology was when she made that statement. Kim Thompson got to that scene and looked at Ken while she was on scene, and she said, something isn't right. Something isn't right. She didn't need to talk to anybody else to figure that out. That something wasn't right. And then as all the pieces of evidence come in, gasoline on his underwear, gasoline on his socks. Yeah, you're darn right. Something's not right. Ms. Stermer, he said, is either the greatest actress or is genuine. Maybe she just got caught. Maybe she didn't expect to have to try to kill him 3 times before it was completed. And that's what caught her off guard, got her upset, and caused her to act the way she did. Mr. Leroy was also a detective. He was a sergeant with the Michigan State Police. He also then approached this for looking at the evidence that he found. This is why he collected the gas can. No matter how hard you try, ladies and gentlemen, you cannot explain the gasoline on Todd's pants, his underwear, and his socks. Mr. Leroy, Sergeant Leroy, also testified that he worked with the insurance company, got all their documents. They talked about a form that they filed with the insurance company. He had access to all their documents. He reviewed all those documents, and when asked by Attorney Blair if he would change any of his opinions after reviewing all those documents, his answer was no. He had access to Mr. Willison, to Mr. Shinsky, and Greg Stornzans, any of their documentation, any of their pictures, any of their information. He had it all. You, as jurors, can look at those pictures and see if that area of origin makes sense. You can evaluate that with Linda's statement. You can make those determinations. Now, you can use the expert's advice, opinions, because that's what they are, is opinions, to help you make those determinations when you're going through those pictures. But you can look at that evidence as well and say, does it make sense? He wanted you to focus on the fact that you just can't find there's a source, didn't know how the gasoline gets there, but consider it when determining it in his data. And so because he can't say that the gasoline got there a certain way, then you must rule it out. No, you can still consider it in your data. You can still consider it as part of this. I think Mr. Trinkle and Mr. Leroy both agreed that the ignition source could have been the fireplace. A lot of talk about not ever finding what the ignition source was. I believe both of them testified that that was an open flame in that room and was the ignition source. He wants you to focus on the contamination. However, if you look at the other testimony that's been provided to you, that boat's ruled out. And Mr. Matheny's clothing was ruled out through testing. Mr. Z, or Professor Z as he calls him, he can say that he thinks the injuries came from the van, but he couldn't match where or what part. He didn't even say what part could have caused the symmetrical on the either sides of the head. He's not a forensic pathologist. He didn't examine the body. There's a total separate laceration on the back of the head that I questioned him about. I said, you can't even see it in your picture, can you? Because he's laying on it. You can only see the top laceration. He was speculating. He didn't even concern himself with the other injuries on the body and where that blood could have come from. You're also going to get an instruction on credibility and how to judge credibility. One thing that you can read for yourselves is that the judge is going to tell you you can view how an expert answered questions as a way to try to determine their credibility. Mr. Trinkle didn't answer questions directly when it implicated his client. He danced around. He was very happy to answer any questions he felt didn't implicate. Yet he also agreed on many points of Scott Leroy's investigation. He also reminded you that his conclusions are always right. But again, he is not the only person to consider in this case. His opinion is not a legal determination. The defense wants to put all their eggs in one basket. Rely on Trinkle. Can't say it's an arson, because ignore all of the other evidence. And if you don't have an arson, you got no crime. That's not what you're here for. You're here to look at premeditated murder, and you're also here to look at the felony murder and all the evidence presented to you. He also went on and on and on about this unfinished living room, yet the boys testified, one said it was 95% done and they were getting ready to paint. He did say there was no carpet. He did say there was no carpet, there were just area rugs. But his testimony was that the walls were finished and they were getting ready to paint. Defense read a little bit of the testimony from Dr. Markey, just the sentences that fit his narrative. But look at his report, look at your notes. And when I asked if you can determine if those lacerations came solely from the van, he said, no, I can only say it's blunt force trauma. I said, can you determine if they came before the fire or after fire? He said, no. He said, no. You can only say it's blunt force trauma. And is also in his report, some of those rib fractures were not consistent with CPR. He detailed it out. He detailed it out. Doesn't want you to rely on Dardita because of her medical conditions, yet Dardita had some very, very, I would call it insider information. And when police pressed her, you have her transcript, pressed her and said, isn't it a frying pan? She said, no, she just said she hit her with an object. Read that. She knew what Linda had told her. He is correct that Todd Stermer died of thermal injuries. But that doesn't mean you can't consider the fact that she ran him over, jumped on his body. You can still consider all of that, especially with premeditation. He died from the injuries inflicted in that fire. If you find that she intentionally set it, then that's where you go to count 2. And count 2 is the felony murder in the commission or the attempt and the arson. So no arson, no crime? It's not true. You have to weigh all the evidence. You have to weigh all of the evidence, all of the elements, and you need to look at premeditation. You need to look at the attempts, the planning, and all that goes towards premeditation. I'm asking you to make sure you read the law and know why you're here. And you're here to evaluate everything you heard separately. You decide what you want to believe. You decide what's credible. And you decide if, based on what you think is credible, if those elements are checked. That's your job. That's your job. It's not to be narrow-minded. It's not to have tunnel vision. It's to take everything you heard and evaluate it. That's why we brought in the people that we did. Each individual piece is important. No piece is more important than another. No piece. You decide what's important. You are the jurors. You are the ones making the legal decision. I appreciate all your time. Thank you.
I had every intention of reading to you final instructions, but I'm looking at all of you, and you look exhausted. So I'm going to send you home for the evening, and when you come back in the morning, we're going to go right into final instructions. I'll release 3 of you as the alternates, and then send you off for deliberations. Okay? Remember the rules. I'm not going to read them all to you again, but absolutely no media observations or talking to anybody. Okay? Thank you. Okay, audience, if you could remain in the courtroom maybe for at least 3 or 4 or 5 minutes here so we can get the jury out, please.
Yes,
To their
yes.
kindness. You don't have to remain standing though. Yeah, and then George will have to figure out.
She's